Okay, I'm going to call to order the meeting of the Sentencing Guidelines Commission on October 10th, 2024, and I will ask Nate to go ahead and take the roll.
Thank you, Madam Chair. Roll call. Vice Chair Larkin. Vice Chair Larkin absent, and Madam Chair, she will be late today, and she'll be socially distancing herself due to she's no longer sick, but she's recovering. Commissioner Crutchfield.
Here.
Crutchfield present. Commissioner Fraze.
Present.
Commissioner Fraze present. Commissioner Knudsen.
Present.
Knudsen present. Commissioner Ladd.
Here.
Ladd present. Commissioner Middlebrook.
Here.
Middlebrook present. Commissioner Moore. Commissioner Moore absent. And Madam Chair, Commissioner Moore had an inevitable conflict at the Minnesota Judicial Center, but he will be here later this morning. Commissioner Morin. Commissioner Morin absent. Commissioner Mueller.
Present.
Commissioner Mueller present. Commissioner Reeves.
Present.
Commissioner Reeves present. Commissioner Saxena.
Present.
Commissioner Saxena present. Chair Mitchell.
Here.
Chair Mitchell present. Madam Chair, there are 9 members present, 3 members absent.
All right. So with that, we do have a quorum, and you may all notice we're in a little bit different configuration today. This is going to be a working session today to help us get our priorities straight for comprehensive review.
Excuse me,
Did you
Madam
miss
Chair.
something?
Yes, I'm operating off of apparently an old spreadsheet. Commissioner Keefe.
Oh, here.
Commissioner Keefe present. Madam Chair, there are 10 members present, 3 members absent.
Oh, excellent. Thank you for updating that. Okay, so just to remind everyone, I'm going to get to the agenda and minutes in just a second, but just to remind everyone, today the morning is going to be focused on doing a last bit of business and getting some additional research input. And then the afternoon will be focused on sort of understanding the themes and prioritization that we want to make for the comprehensive review going forward. So a little bit formal, a little more formal this morning and way more interactive as the day goes on. For now, to round up the formal part, we have the agenda. The second item is approval of the draft meeting agenda. The only thing I would like to do is to move the executive director's report up to right after lunch. We'll have him do that before we head into the interactive portion of the afternoon. I think that'll be cleaner. So I would entertain a motion to approve the agenda with that amendment.
So moved.
Commissioner Reeves makes that motion, and do we have a second? And Commissioner Middlebrook seconds. Any discussion on the agenda? Hearing none, please go ahead and take that vote.
Madam Chair, I'd be happy to, but this is an in-person meeting, so it's you can just.
Oh my God, I get to do this. Oh my gosh. All of those in favor, please say aye.
Aye.
Any opposed, same sign. Hearing none, the motion is approved. Woo, that's so fun. So much easier. Okay, second, I would entertain a motion to approve the draft meeting minutes from September 12th. You should have received those last week. Commissioner Knudsen.
I can't really move it. I wasn't here, but I have a correction.
Okay.
Page 2, item 4 talks about the supplemental budget request for fiscal years 2026 and 2027. The language is 2026 and 2026.
Oh, it repeats 2026?
Yeah.
Oh, thank you for that.
Okay, so we would change the second 26 to a 27. All right, so then I would entertain a motion to approve the minutes with that correction.
So moved.
Is that Commissioner Ladd? Or Commissioner Reeves? Thank you.
Wait.
Commissioner Reeves makes that motion. Commissioner Ladd, second? Sure. Okay, great. Any discussion on the approval of the minutes? Hearing none, all those in favor, please say aye. Aye.
Aye.
Any opposed? All right, that motion is approved. Motion carries. And then the third item on the agenda is the stay of adjudication and custody status. And I'm going to turn that one over to Nate. And this is a discussion item only today, so we're just going to be getting some more information on this topic.
Thank you, Madam Chair. You have two documents in your meeting materials today that are really just updates to last month's discussion on the case of State versus Woolridge Carter and the fact that under Woolridge Carter, that the rule is now that stays of adjudication, probation do qualify as custody status. We discussed several courses of action last month, and one of those courses of action was that the commission may wish to abrogate Woolridge Carter because it was an interpretation of the guidelines. The commission is free to change the language of the guidelines to clarify its intent. And we did have some draft language. Commissioner Ladd pointed out that the language didn't foreclose the possibility that someone might construe a stay of adjudication. We were kind of looking at it from the perspective of probation because that's how it was. The issue was teed up in Woolridge Carter, but somebody might also look at it as release pending sentencing potentially, if one might be creative. And so we thought that was a good point, and we were just offering sample draft language that hopefully closes that loophole as well by adding a clause at the end of the draft language. That's the first paper, and by the way, if the commission does wish to take action on this year, the month to take action would be the next meeting in November, and then it would be that would be timely where we could then publish a notice in the State Register, have a meeting, have a public hearing in conjunction with the December meeting, and then take final action at the January meeting. So that would sort of be the timeline if the commission did wish to change the sentencing guidelines in this way. The second paper is an impact estimate, essentially the equivalent of a fiscal note, an estimate of the impact of the case of State versus Woolridge Carter. It's difficult to estimate the impact because before Woolridge Carter, stays of adjudication were not considered to be custody status, so we didn't have any data on how many stays of adjudication, how many defendants were appearing for felony sentencing with while on probation for a state of adjudication, being that it wasn't, it didn't apply. So what we did do is we looked for counties that immediately implemented Woolridge Carter when it was decided at the Court of Appeals level, which was about, I think, 13 months before the Supreme Court decided it. So we did have a possible window there. And the data strongly suggested to us that Sherburne County had immediately implemented it because Sherburne County, I should say immediately implemented it and documented it in the way that we had asked probation officers to document it. Because Sherburne County had a noticeable increase, especially for the size of the county in those kind of cases, it really led the state. So we assumed that Sherburne County's experience was going to be a typical experience going forward, and we came to the conclusion, if that assumption is true, and you were to spread those effects out statewide and apply additional custody status points to the number of cases that would have additional custody status points on a random basis, we determined that there would be 148 cases where folks would be getting a custody status point for the state of adjudication in their sentencing, the full custody status point, and that would eventually require the need for an additional 31 prison beds. And that's approximate, but I think it does give us a ballpark idea of the magnitude of the issue in terms of practical effect. If I didn't say it, that's 141 cases per year, so that's an annual number. And that's really all we had to report, just kind of an update on that. Again, pending any action the commission actually wants to take in November.
Any questions, Commissioner Knudsen?
I was telling Nate when we first got here, hey, boy, when you miss a meeting, it's kind of a big deal. And they play catch up on what the discussion was last meeting. I have a couple questions. So you use Shelburne County because they're the only ones that
So-
responded to the commission's instruction on how to record that?
Well, so when the Court of Appeals made the decision, which was the same, it was actually the same all the way along, District Court, Court of Appeals, Supreme Court, everybody agreed that the guidelines didn't say what the commission thought they said, basically. And the guidelines, though the way they were written, required custody status for stays of adjudication. And almost immediately there was a petition for further review by the defendant in that case. And so I think some counties, maybe most counties, were kind of waiting to see what the Supreme Court ultimately said on it before they took action. But there is case law now that says that Court of Appeals opinions are effective, even if there is a petition for further review. Court of Appeals opinions are immediately binding on other jurisdictions. So I think some jurisdictions maybe implemented Woolridge Carter at that point, but didn't record it in a way that we could track it. And some jurisdictions maybe were like, we're going to wait and see what the Supreme Court says. And maybe some jurisdictions weren't even aware of the issue. So I think of those three categories, the only one that was clearly in the category of, we're aware of the issue, we're going to document it correctly, and we're going to implement Woolridge Carter right now, even though it's still pending further review.
So that's my question though, on the documented correctly.
Right.
How do they know? How do we get that message out? And what's the compliance?
Well, in the future, we're going to hopefully make a change to the electronic worksheet system so that it'll be clear that there'll be, the problem is there's not a checkbox on the electronic worksheet system for probation following stays of adjudication, because that wasn't a thing. So what we asked probation officers to do is mark it as, interestingly enough, release pending sentencing, and make a note in there that says, this is a Woolridge Carter case. So those are and Sherburne County did that. So that's how we know about the Sherburne County ones.
So they did that on their own, or we knew it from the guidelines that they were actually implementing it, and we wanted to get to them right away to make sure that they were keeping track of it possibly?
Well, after the Court of Appeals decision was put out, we Linda, you can correct me if I'm wrong, but after the Court of Appeals decision was put out, we gave guidance statewide that says if your jurisdiction is adopting Woolridge Carter and adding a custody status point for probation following a stay of adjudication, we want you to note that by, one, checking it as release pending sentencing, and two, making a note in the comments that says this is pursuant to Woolridge Carter.
Okay, that's what concerns me. We send that out, and we can only identify that Sherburne paid attention and followed that tracking system.
Well, yeah, I mean, or other counties just weren't doing it. I mean, I think I could see a reasonable county attorney saying, we're going to wait and see on, what the Supreme Court ultimately does with this.
Okay, so then we were only informed or only discovered that Sherburne was the only one that was actually implementing it and doing it.
No, not entirely. So if
Well, I don't want to belabor this anymore.
Yeah.
As these listening sessions are very, very helpful, and one of the things is the uniformity of our instructions and of probation implementing and proper tracking, so we can get data back that's consistent across the state. And so this just raised that issue in my mind as I was looking at this. So how do we, ensure that this is the way to do it? You need to do it this way. This is the way the system's going to be able to track it. And do they pay attention to us? That's I just guess my point. I don't want to.
So let me, one thing I would interject just to be clear. So now that there's a Supreme Court decision on how this goes out, we're at an inflection point where we have to decide as a commission, do we want that to be the way the guidelines are read, or do we want to change how the guidelines are read to put them back to where they were? If we if our decision is that we're gonna go with what the Supreme Court said, what they would do is actually do an update to the electronic worksheet system that would make it very much easier for probation officers to track it. So while we were in this space of this case is being challenged, they wouldn't have done that. They would have just provided guidance on how to do an interim tracking system in the meantime. So I think there's, like, yes, there's definitely a theme that we've seen across the board of like more training and more help with doing things consistently. But I think this is a weird situation that doesn't fall into that same bucket in many ways. Commissioner Ladd?
Just as an aside, so that I understand, like, when we talk about, we communicate this, push this out for information to probation, just generally, how does that happen? Does that, because we obviously have three, we have different models of probations in the state. So like, when we have a communication, what does that look like and who does it go to? Just generally, how does that work?
Well, we have a roster of probation supervisors, and so we send it out to the probation supervisors. I'm looking for head nods from Linda here, but yeah.
Okay.
So regardless of the three systems, there's a finite number of probation
And
supervisors.
that's what happens in this circumstance.
No, that's not.
We handled this on a case-by-case basis
Oh, okay.
because it was pending and there had been no decision. It had been, once it went from the appellate court, what we will normally do is take them on a case-by-case basis. So an agent calls to ask, or they've indicated something on their worksheet, and we explain to them how to correct it. And then once it went to the Supreme Court, we were a little more proactive if they said, should I tell everybody in my office? And we said yes. But it's always pending what is the decision of the commission, for the commission to tell them what to do. And then once we have that information, we have the mechanisms in place to reach out quite quickly with the appropriate means of going forward.
Thank you, Linda. And I think I misspoke then earlier. So we didn't push it out. It was more, we responded on a case-by-case basis. And that may answer your
Yeah,
question.
thank you for that clarification.
Commissioner Knudsen?
One other question, on the impact, it's an eventual need for additional 31 prison beds over what period of time?
So there is an implementation delay, but ultimately that's like so the way a prison bed works is, that's just sort of the number of additional physical beds that the DOC would need to implement this policy, as opposed to a policy that did not have custody status for states of education. So, at any given time, there would be 31 prison beds needed.
I guess that answer is actually on the last page of your.
Okay.
Thanks.
Yeah, and we could get into the other counties that did. There were some other counties that on sort of onesies and twosies did have some states of adjudication for custody status, but the
If I may just say, Sherburne County had 12%, 12.6%, and then the next district or county was St. Louis County, which had 8.7% of the cases, which was just 9 cases, but otherwise Sherburne had 13 cases.
yeah, and you got to keep in mind Sherburne's only 1.5% of the caseload of the state, so that's pretty significant for a county of that size to have 12% of the cases statewide.
Any other questions or comments? All right, well, thanks for pulling the impact together. We'll go ahead and bring this back to the November meeting for further consideration. And I think that's it for substantive, like, our business today. Item number 5 is an update from Professor Hugen and the research team at the U of M.
Great. Well, good morning, folks. This is more of an academic conference setup for me, so I'll try not to be too informal, as we tend to be. We have a lot of our Minnesota research team here, so I will start my video. share my screen. Let's see. There we go. Hope folks can hear me. I have my sound off, of course. Nate will tell me if I'm in error here. Today what I'll be talking about is sentencing departures, and part of this is to update you on some of our progress. Part of it is a reality check that we learned so much from the real experts in the room as we do this, and before we proceed to the next phases of the research. Just to put some of this in context, as you've seen presentations from my colleague Kevin, from Commissioner Fraze, that really, in my view, put the MSGC in legal and historical context. That is relative to other sentencing commissions, federally, or we heard a presentation from Pennsylvania, I believe at the last meeting, that was extremely informative. We also heard from Matt and Julia last week or last month on the rising presumptive prison rate, which is closely tied to departures, and how increases in average criminal history scores, mandatory prison sentences, and average offense severity, certainly on the drug grid, have helped to drive that rate. They are, Julia wrote to say, you know, they're currently looking at the causes of these trends and how grid placement, especially with mandatory minimums, affects mitigated departures. So early results at least suggest that judges are more likely to depart in these types of cases. Today, as I mentioned, I'll be talking about sentencing departures, and then we'll kind of conclude, and we have Aaron Sojourner here in the room, also on the Minnesota team, with some kind of big picture ideas that we wanted to float about some more expansive research ideas. I did get that grid put up, Aaron, by the way. So let me just give a little bit what researchers do. I won't give the whole like 30-page literature review that we're throat clearing that we all have to do as researchers, but it is important to note that a lot of what people have written about these questions is based on federal guidelines rather than state guidelines. Although it is clearly relevant to us. The focus for a lot of the academics has been on kind of sorting the legal factors from the extra legal factors in sentencing and trying to sort those out. One of the things that I've learned, and we have Nick and Ethan are terrific research assistants there. In our review, we've noted that there's real offense specificity. That means that departures, who gets departures and what's the impact of those departures really depends on the offense for which those departures are given, and sometimes the institutional mechanisms that lead to those departures. There's also a relative, I would say, a somewhat more limited literature on judge surveys. And I put up a quote from Jeff Ulmer and Brian Johnson here. It says, listen to the signals that judge-initiated departures send, because these may indicate an important lack of normative alignment between guideline sentences and the attitudes of, in this case, district judges. This was a federal study. See, in this way, judicial departures are not necessarily indicative of troublesome noncompliance with the guidelines, but instead have normative feedback value. And that's a little bit of academic jargon, but I think the message is, what are the departures trying to convey to us about the sentences themselves and about the attitudes of judges? And I know in the MSGC review process, these are questions very much upon people's minds. So I just wanted to link those questions at the outset. Let's see. So the questions that we've been looking at are some things that are well addressed in the Commission's 2024 report. but getting a kind of a broader lens on it. How are departure rates trending? For which offenses? Who gets departures? And then is departure linked to reconviction? And if so, how? Then as I mentioned, the deeper questions are about what signal is a high departure rate sending? And what, if any, action that the commission might want to take to address the high departure rates? That's a you question, not a me question, but it does say, well, if a 40% departure rate is high or perceived as too high, what are the steps that might be taken to address that? So this is a figure, a long-term trend in the rate of mitigated dispositional departures for presumptive commit cases. And I know that if I were lecturing, to an undergraduate class, I would have to explain a lot about what's a mitigated versus an aggravated departure. What is a dispositional versus a durational departure? But I'll move rather quickly through those. But these are cases in which I'm even hesitant to oversimplify with Kelly and Nate right here, but cases in which somebody might have been a presumptive commit to prison but did not go to prison. So
Don't ever worry about oversimplifying.
Well, I've got a little tension, I would say. And as I say, it's a little intimidating, honestly, as an academic researcher to come in with, as I say, the real experts. But you can see kind of an increase in the departure rate over the last 40 years. And we have a bit of a pandemic era blip, in which things, you might have had a spike there, but the long-term trend is fairly high, is fairly upward and high. So now I'll show one of the things that Nick Dickens worked up for us is a visual, and it's probably a little hard to read with the labels, but just to show how the offense mix has changed over time in terms of the top 10 mitigated offenses with mitigated departure rates. So I'll just play this briefly and pause. So in 2001, the highest rate departure was registration of predatory offenders, first offense. And then the assault to dangerous weapon. And we'll move through fairly quickly. So if we're up to 2002, those are relatively stable. We have second degree possession jumping up, and then dangerous weapon. But you see some similarities there. The color-coded offenses are those that appear regularly on each list. So the stop in 2016, dangerous weapons, registration, and burglary are the top three, and then first degree DWI is starting to appear on the list in this period of time. Then we've got threats of violence, and oops, I want to make sure, I want to go back and move out to more recently. We have dangerous weapons, predatory offenders there, but also first degree DWI, possession of burglary tools. So these are, so it's not a stable list, that is that there's year-to-year variation, but the same types of offenses often appear. And so those are some of the offenses that we kind of focused on closely. And there's a reason I'm focusing on mitigated departures here, in part because aggravated departures are a sharply declining percentage of all departures, and also because there's been changes in the classification and measurement of those over time. But we also have done the similar visualizations for aggravated. And then we can do a similar exercise with just, okay, what's the share of all departures that are that this offense category represents? And it's a similar graph, or a similar picture, that dangerous weapon offenses in 2001 were very common a departure offense and made up a large share of the total departures, over 15% here. And if we proceed out, stop it, dangerous weapon, registration, second-degree possession. This was methamphetamine in 2004, cocaine. We go out. Again, registration, assault to dangerous weapon. This accounts for a large proportion of the overall share over that 20-year time period that we're analyzing. Fifth-degree possession. Then more recently, felon not to have firearm or ammunition is making up a large number. Fifth-degree possession. Some of these possession offenses pop up on both the aggravated and the mitigated list, which was a bit of a surprise to us. And I also realize, my students tell me in my evaluations that I have a higher tolerance for charts and graphs than they do. So I'm wary of that. I told Nick, we're not going to show all of these, of course. But let me summarize, in words here, some of the offenses with the highest rates of mitigated departure were this assault to, registration of predatory, felon not to have firearm, some of the possession offenses. Durational possession offenses were quite common. Threats of violence often got a mitigated durational departure, means a lower amount of time. Fleeing officer, theft of movable property, and felon not to have firearms. So it's not to say that these are the pain points in the system, but these are areas in which the judges are routinely departing from the grid. Now, who receives the mitigated departures? The age is a pretty close correlate here. Both the youngest and the oldest defendants coming forward are likely to receive mitigated departures. So that is, the 18 to 21, 50 plus are likely to get dispositional departures. Those with the lowest criminal history scores, not surprisingly, are likely to get departures. White defendants are likely to get departures relative to, say, American Indian and Hispanic defendants, females relative to males. In recent years, there's been a relatively high number of departures in Ramsey County in the 2nd District, and people who do pleas rather than trials. And all of these things, we're just presenting kind of top line, not controlling for other case characteristics, of course. Durational departures, Black defendants are more likely to get mitigated durational departures. We see one figure that I just show on I can move my head over here. The percent of mitigated durational departures by sex has converged to some extent over time. At least in terms of durational departures, there is still a wide gender gap with regard to dispositional departures, like the in-out decision. But the rates of durational have converged. Is that a known pattern? So that was something that Nick had flagged in particular. So I wanted to show that. We of course have lots of charts and graphs on all of these characteristics, but again, in the interest of time and good pedagogy, I won't go through all of them. So we also have some other visualizations that I can show you around these, but I think I'll move by those fairly quickly. Some tree maps. when we go to the offense specificity, try to map out, okay, well, what, for each of these categories, what percent are getting mitigated dispositional, mitigated durational, mitigated dispositional and durational, neither. And this is so this gets us a little more refined in terms of what, how we might see each of these offenses. I'm going to present some work now that is preliminary. We will be presenting some material in about a month at the American Society of Criminology meetings. And so I say it would give some kind of broad patterns, descriptive patterns and results, but not yet adjusting for all of the case characteristics that we would like to do. So the descriptive information is very valuable, but it's also subject to change as we adjust for important case characteristics. But what we've tried to do is say, well, okay, what happened to the people who got departures? Were they more likely or less likely to be reconvicted and to show up back in the system? And so as our first cut at this, we've tried to identify people who had a first felony conviction, or I should say, the first felony conviction in our observation period, which was 2001 to 2022. First time they appear in the data. Did they get a departure or not? And for what offense was the departure? And then we try to follow up and say, did they have a subsequent felony conviction? If so, when and for what? And so obviously it's important to consider like any felony reconviction, but we also try to create a subset of serious personal offense convictions, which may be of greater interest in terms of public safety. So there's a couple of ways to think about this. And on the one hand, people who get mitigated departures should be better bets to avoid reconviction in the future. They're partly selected on that basis. So we might expect some relatively lower rates. On the other hand, people who get mitigated dispositional departures in particularly have far fewer controls on them, far less surveillance, far less control. And so in that sense, you might expect some higher rates of reconviction. And clearly, to avoid reconviction altogether, you should have mandatory life imprisonment at the first arrest, and then you could solve the whole thing, right? I mean, and I say that, but then many of us in this room would not be in this room. So there is a balance between the kind of costs to society, both socially as well as economically, of punishment, and the cost to society of subsequent crime. So I'll show you a few illustrative examples just to give you a sense for how this analysis is currently shaking out. Although with the caveats that again, it's not necessarily apples to apples. It's probably apples to oranges or bananas. It's not like apples to, I don't know, pickup trucks. I mean, we're getting a little closer. Again, with those offenses that occurred on the list, and one of the reasons we want to focus on those that have heavier departure rates, because then we also have less noise in the data because we have a significant number of cases. So let's look at dangerous weapons here. Now that's a better place for my picture. Okay, the assault to dangerous weapon, we had about 4,000 cases over the period. About 2,800 of those were mitigated. We tried to divide the period of reconviction into where you reconvicted during the mitigation window, during that time in which you would have been subject to incarceration or something else. And this is telling us that that in our sample, about 27% of those who didn't receive mitigated samples, were reconvicted for any offense and reappeared in the MSGC data set. And that is a recidivism measure, we can consider it that, of reconviction, which is often superior to using something like arrest or something that is much more subject to bias, potential biases. Now, if we look at the group that was mitigated, we've sorted it into that during the mitigation period, during that window, and after. And you can see it's still, we're getting about 27% reconviction of people who had these dangerous weapon offenses. But when it occurs, or I can't even say when it occurs, can I, Nick? That many of those are occurring during that mitigation window, but the overall rate is quite similar. We can probably detect a statistically significant difference, but I'm not sure if it's practically significant there. Yes.
I don't mean to interrupt. I just want to ask one clarifying question. So when you talk about dangerous weapon, is this analysis making a distinction between firearms or other dangerous weapons, or they're all in the same category?
This is anything charged under that statute. So this is the time I've learned as a UMN researcher that I will email Jill this question. And so Jill, I don't want to lean on you particularly, call you out, but.
Well, I guess, thank you. I would ask the question, is it a felon in possession of a dangerous weapon that we're talking about?
It's assault.
Oh, assault too. Oh, okay. With a dangerous weapon. In that situation, there would be an indication on the sentencing worksheet that some kind of a firearm or dangerous weapon was used.
Well, the reason why I asked the question is obviously because if it's a dangerous weapon, not a firearm, the mandatory minimum under 60911 is 12 months in a day or 12 months. Mm-hmm. And then the firearm is the 3 years. So when we're talking about these departures, it would be an interesting point to know if those departures are coming with the gun offenses, which have the mandatory minimum of 3 years, versus all other weapons. Could be a baseball bat, could be a knife. Yeah. On the year and a day. And I do think that distinction is different between those kinds of dangerous weapons, just from my perspective and looking at those departure rates.
Yeah, it's an excellent question, Commissioner Ladd, and we do have a breakout, I'll show you in a moment, on felon in possession of a firearm.
Well, that's a separate offense. I'm just talking specifically about the weapon category, because I do think guns are, in my mind, guns are different than all other kind of weapons. Not that they're not all dangerous, but I do think that in our analysis, as we look at these mitigations and where they're coming from and why, I think that helps instruct us sort of in looking at it as a whole.
Excellent point. Yeah, and I'm not sure how much we can recover from the data there.
You get some, because there are some indications of like, was this a gun? But there are different variables. Was this a crime?
Yeah, so that is a breakout that we can do next week, right? I won't say today.
Don't we do that on the 61911 reports that get filed with the?
Yeah, that's different though. That's prosecutor provided. I was going to ask you, is the type of weapon in the MOC code? Is that where it's recorded?
Yes.
So I think they have the MOC codes.
The MOC codes. Okay. There might be some either unknown or other, but there is like guns, and it does go through. There's a list of them in those codes.
I don't know if it's helpful,
Yeah.
Chair, but so on the sentencing worksheet, we do have, if it's a dangerous weapon, other dangerous weapon, or a firearm.
Okay.
Now, if you wanted to know what kind of other dangerous weapon, then we would need to, if it was the baseball bat versus the knife, if you wanted to know that would be through the Minnesota offense codes. But otherwise, we can, with a variable, look at if it's a dangerous weapon versus a firearm. If that's
excellent.
I personally just think that understanding the guns and everything else, as we're looking at these departures, where they're coming from, because that might be telling us something or a signal to something in a broader perspective of all this.
Exactly. Thank you so much. And please, this is invaluable comment for us, as we want this work to be as useful as possible. Let's proceed to another common offense, registration of predatory offenders, first offense. So this is, we had about 1,900 of these cases. Split, a high proportion were mitigated. And here too, we have a fairly similar overall rate of reconviction. It's a pretty high rate of reconviction. We found, it appears that in these data is that many of these reoffenses are another failure to register. So a subsequent failure to register. So when we look at reconviction, if we take that out, those rates drop. So and so that's the sort of, and when I say offense-specific analysis, we really have to do that sort of thing and be conscious of, okay, what is driving that? Because that seems like, I said, well, 25% was the last average, or 27%. Now we're up to 40%. But that's partly because it's a bit in the nature of the offense. So so here too, about 11% of these reconvictions were occurring during that departure window. The person might otherwise have been punished. In about 28% after for the mitigated group, and then about 39% overall reconviction rate for those who were not mitigated, who the law was imposed on.
So is anybody that's convicted of this offense not re-convicted of something?
Yes. So 60%, I mean, so that is a, and there are some wonky things we have to, regarding the data that we can refine. Like, so the risk period differs for persons because some people entered it in 2001, some people entered it in 2010, and they have 10 years of follow-up. Some people have 20 years, some people have a year, So with those caveats, that is, when I calculate recidivism rates or reconviction rates, I often say a 3-year reconviction rate or a 5-year reconviction rate. I won't necessarily apply it to the broader period like this. Although I do have 74-year reconviction rates for another project. Yes, Commissioner.
Well, you had the number of cases that were mitigated for dangerous weapons, and you said a high number here. Do you have the number for cases of the predatory offender registration that were mitigated?
Oh, so among the predatory offenders, how many have a dangerous weapon?
The 2,000. I think you had a number for the assaults. You had 4,000 cases and 2,800 were mitigated that were part of the group.
Yeah. How many, Nick, do you have that handy?
So out of the 1,900-ish here, 1,350 got the mitigated dispositional departure, and 507 got the didn't get that mitigated dispositional. And this is just among presumptive commits. Yeah, and also just to clarify, these two bars here, they don't add together. They're within the people who did not get the mitigated departure, 40%.
Right.
And then within the group of people, that 1,350 who did get the mitigated departure, 40%.
Thank you.
Yeah. Commissioner Fraze.
I'm just confused about this one and I guess the previous one, because not mitigated is one group of offenders, and mitigated is another group of offenders, but the numbers, I mean, it's just too early in the day for me.
Yeah.
The numbers are summed to 39.
Yeah, so the omitted category here are the no reconviction. So that there's about 60% no reconviction in both of these figures.
They don't have to be equal by construction. They just are equal.
Oh.
Right. Sometimes you realize you left an important part of the presentation out. And so, yeah, so this is a picture, these are pictures in which we have relative parity. So so essentially we're getting the same amount of reconviction, whether it's mitigated or not mitigated for these specific offense categories. Now, I'll show you another one, like, so we're our first cut at the data, and again, with all of those caveats I mentioned, felon in possession of firearm, again, a separate offense. We have about 1,400 of these cases total. Nick can tell us how many were mitigated. I tried to simplify the slides, and I probably oversimplified them.
That's
Yes,
interesting.
1,400, about 753 were mitigated, 685 were not.
So pretty much a 50-50
Yeah.
split. So here, we have a higher reconviction rate among those who had mitigated. That is that, we have about 24% reconvicted in the not mitigated group and about 35% in the mitigated group. And much of that is occurring during this mitigation period. So this is, this is a different pattern. It's saying, well, okay, we want to take a closer look at these. And we don't yet have our severe person offense reconviction totally coded up. I'd say one thing we did is to say, well, was the first reconviction something that would appear on a list of crimes of great concern, more predatory offenses that include, murder, rape, aggravated assault, robbery, etc. And here we have about 1.6% reconviction in the non-mitigated group and about 2.1% reconviction in the mitigated group. Again, that's only on the first offense. What we're going to do is extend that out over the entire observation period and see, did somebody who got the mitigated offense ever have a reconviction for these crimes of great concern? We do want to do a little more refinement on that, and better understand why certain crimes are classified in the way they are. But based on the grid structure, we've tried to identify that those crimes and to say that that when we do this for the failure to register crime, those 40% reconviction rates drop significantly as well. Or when we do it for the assault 2, the percentage that do where we could consider it, and I know that every crime is potentially serious to those impacted by it, but that we can get a sense for the gradient of severity and potential harm or risk to public safety. Oh, yes.
Yeah, and just to make it very explicit, so this means that 98% of the people convicted for possession of a firearm, aren't reconvicted for a severe crime of concern on their if they're reconvicted at all, it's not one of those, or they're not reconvicted.
Right, and I hope that makes sense to people, at least, and that's where.
Exactly.
Yeah, and we want to make sure that we get a, apples to apples window that we're comparing. And so, as I say, I'm treating these as illustrative examples rather than final research. And I will share, our updates on all of this information prior to the criminology meetings, so that as we develop it. But I wanted you to see these kind of analyses we can do. Now there are many others, and typically, I will work with a DOC release cohort and follow them out for reconviction, or I will work with other things. So this is, but the Guidelines Commission data themselves, this is all based on Guidelines Commission data, and is this sort of analysis that can be done more routinely. I just caution that as you get into smaller categories, if you have only 50 departures, then it's going to be pretty noisy. Like those graphs are going to jump around a lot from year to year or district to district, et cetera. So I will leave some take homes here and some potential discussion points. One, obviously, as the Guidelines Commission reports made clear, departures have been concentrated in particular offenses. They've become a bit less concentrated in the last 20 years. That is, there's more diffusion. There's less. The top 10 account for a somewhat smaller share these days than 20 years ago, but still very heavy in particular offenses. We have some good sense about who receives them, and I'm starting to introduce some information about their relation to reconviction, and that key safety, and then managing correctional populations question. We're clearly working on refining and developing these analyses. And then, some of the larger points, I do think, what are the signal that departures are sending? And I think, to Commissioner Ladd's question, they're likely sending a different signal for different offenses and different elements of different offenses. That to me seems really key, and the sort of textured analysis that I think that the Commission is undertaking and examining. And then I'd encourage, folks in the discussions this afternoon to think about what are your short and long-term research needs? What kind of information would be really helpful to have in decision-making? And I think, as I speak very highly of the Commission staff and folks' ability to do, these analyses well and better, perhaps than us. And then I wanted to say something about improving on, our own ongoing work, but then developing new research on some of the broader impacts of sentencing. And here I'm going to put up my last, clunky chart and turn to Evan about the statewide longitudinal education data system.
Yeah, so I wanted to share this with you. This is a system that's run by a partnership of agencies, OHE, and the Office of Higher Ed, Minnesota Department of Education, and DEED, the Department of Economic Development.
Yeah.
And they've put together a bunch of administrative data sets and made it accessible to public agencies that have an interest in this data, research partners, and it's hard to read, but basically what you have in the rows is different data types and then agencies, and then in the columns you have years. And so you can see where the blue X's are, that means the data is available in those years. So for instance, on the top row there, they have ACT scores for all Minnesota students basically back to 2006. They have, if you look at the last, there's a row there for employment from DEED that goes back to 2003. That's like all the unemployment insurance records for all employers and all employees in the state every quarter, for more than 20 years. So you can find an individual and you can find every job they've had, and you can find how much they made every quarter. And in Minnesota, we have a very good system, which not a lot of states have, where employers actually report not just quarterly earnings, but also quarterly hours of work. So you can actually calculate like hourly wages for each person each quarter. So you can see their kind of earnings trajectory. You can also go back and you can get K-12 like test score data. You can get attendance rates. You can get things like that. So for the MSGC, thinking about people who are passing through the judicial system, linking to this kind of data can be very useful for two big purposes. First, when you're doing the kind of analysis that Chris was just talking about, where you're trying to understand the effect of mitigated departures, and you want to isolate the effect of the departure, and you want to separate that from outcomes or influences that might be correlated with the type of person who gets a mitigated departure versus doesn't. Within MSGC's data system, you have things like defendant race, gender, age, criminal history, things like that. But now imagine you can go back and you can actually control for the neighborhood they grew up in, the schools they went to, how they did on tests, their attendance rates. So you can get much better measurement of who they are and where they came from, and how similar they are, how different they are from each other. And it can improve the credibility of the comparisons you're making, because you can say, look, here are people who grew up in the same neighborhood, who, you can imagine. And then, they're showing up. So you can control for a lot of different things that you wouldn't be able to without this kind of linked data. The second purpose is that you can also use it for outcomes. So you can say, going forward, here's people, one person got a mitigated departure, one person didn't, one person was subject to a guideline policy, with this number of months as the recommendation, but then the next year, the commission changed its policy for that type of offense. So this other person who's very similar, was exposed to a more stringent guideline policy recommendation. And so you can start to say, okay, look, we can see within our own data the sentence they got and their journey through the correction system. And you can see the impact on public safety, perhaps through reconviction and recidivism. And that's an important value. But another important value is being able to see how productive people are in the community. And so if you can see that getting a mitigation or being exposed to an extra year of prison time, does that impact their earnings trajectory? Does that impact their employment trajectory? Does that impact how productive they are in the community? If they were free for longer, what are they doing with that time? Are they getting a job and earning money, or not? So there's a lot of data there, and I think we'd like to try to link the MSGC data on all these defendants into this data system to both get better controls and histories for the people, and to get better forward-looking, what happened afterwards if they were subject to different policies and decisions in the criminal justice system. How did that impact their life in the community beyond the justice system?
And to that point, Aaron, that's what, when they're doing this sort of graph, you say, well, what happened to earnings in during window there in the second column? Were people working and productive? Right now, that's kind of a black box for most researchers in our field. So that's one of the, if you put economists and sociologists and legal scholars together, you're going to get, project ideas like that. Right, Commissioner Freitas.
I just had two comments. One, just on the SLEDS data, this is just fantastic data. And I guess I will be curious to see how, the before and after mitigation variables compare, and also how those variables compare to it's not a controlled experiment, of course, but judges are making, when they make amenability decisions, in particular amenability decisions, they're looking at a lot of this stuff. And of course, it's formally not permitted under the guidelines, but it does correlate pretty strongly, I'm afraid, with the initial offense and with subsequent offenses. But anyway, I mean, that's fascinating. I guess that the other comment was that back to the what signals did the departure send us? And this is sort of parallel to Commissioner Ladd's suggestion. Let's get the breakdown on what kind of weapons. I would be interested in the breakdown. I know there's a variable for did the prosecutor object, because it isn't just the judge that's sending us a signal. It's the whole team of decision makers, prosecution, defense attorney, probation. And I don't know whether, I'm pretty sure, well, I know there's a variable for prosecutor objection.
Right.
I've seen it in reports. I don't know if there's any way to measure what did the PSI recommend?
Yeah, I know that, the prosecutor, and that does appear, the PSI, I'm not sure, do we?
I mean, the PSI itself is private data, so we wouldn't have access to that. We only have access to the prosecutor's position if the judge indicates it on the departure report.
I would just add, there is one variable for agreement with court services, agreement with treatment professionals. Those exist as well and are coded as one of 4 reasons if it is indicated on the departure report.
Okay.
Just to follow up, are there guidelines in any of these probation systems for how those recommendations are made?
Commissioner Reeves?
When you say guidelines, that's the word.
Policies, you might want to consider this, and this about the offender when deciding whether prison or execute prison is appropriate or not.
So when we do our evaluative summary, we write all of that. So if we feel like it should be different from what the plea bargain was, for example, we would write in the evaluative summary, and then we put the information about the sentencing guidelines in our report at the end and saying, however, probation, et cetera, wants to do A, B, or C. But the plea bargain was this. They do have the capacity to do that, and then they do the recommendations following that. But it just depends. They do have, I won't say a template, but an idea based on the offense, what normally happens and comes out of probation for that offense to look off of from supervisors.
The other thing that the probation PSIs outline, there's a plea agreement, or if it's an open plea to the court, or it's just a sentence to the courts can make a sentence, is the probation agent identifies both mitigating and aggravating factors that are present in that case. There's a section in the PSI where they sort of break those things out in addition to all the other stuff. So it identifies as a neutral party to the court those 2 categories, if they exist or not.
At least from their perspective.
Yes.
Right.
But it's in that document.
And that might look different from county to county.
Yeah. The PSI studies I've seen have been county specific.
Yeah.
And there'll be an analysis, you have an agreement, a confidentiality agreement, and then you can do tend to be more qualitative. Commissioner Knudsen, did you have one?
Just a follow-up for Eric. You're telling me that we got all that data linked to individuals?
Yeah. It's not public. It's not
Right.
like you can't just go look at it.
Right.
You have to go through a process. But yes, it's not all linked, but it's all linkable, and they will,
Right.
Minnesota IT, there's a process. SLEDS has a governing board. You apply and you describe what you want to do and who's going to do it, and they approve it, or they negotiate with you about it, and you come to some agreement, hopefully, and then Minnesota IT has a process to link across. Yeah, so they know you know, Aaron Sojourner went to this high school, went to, you know, went to work for this employer, and can recognize by name, by birth date, by race, by age, by gender, by social security number sometimes, or, you know, sometimes they have that.
Wow, that's just amazing. I had no idea. I thought we
Yeah.
that up, it's just, we've got, combined data on some, on our population, but I didn't know you could actually get to individuals.
Yes, so MSGC has identified data on, you know, all these folks, and that's great, because then you can take that identifying information to SLEDS and say, hey, hook us up, you know, and they give you back, you know, we have to figure out the right process to protect privacy and avoid disclosures. But I think we can explore that. I can't promise we can do it, but we can explore it.
So maybe just to ground myself as a newer person, before I get too excited or freaked out. Are we trying to examine bias around like signals and how decisions are made? Are we trying to look at how, like thinking about the other conversations that we're going to have today? Are we trying to look at what rehabilitation can look like and what resources can be put in based off of what folks' histories and lives look like? Like, how might we use this information and what decisions or things do we need to be thinking about? Or is it all of that?
No, I think that's a really important
All of
question.
that?
You know, so a few months ago, we defined some research questions, and I don't know if you were, how new you are.
Very new.
Yeah, okay. So I don't know, maybe Chris has a better summary on it.
Well, yeah, and I'd say in this process of getting the SLEDS data, and Aaron and I are both in various stages of this process on different projects, you have to spell that out, you know, exactly what is the state interest here and it's not a quick process, you know, we don't have the data on our computer or anything. I think the one of the hooks for me is to define what does success look like after punishment. We know what non-success looks like. And so how are people doing? If they are avoiding crime and reconviction, that's one thing. And how have they proceeded educationally? How have they, you know, you can answer things like, do the GEDs earned in prison have similar effects to the GEDs earned elsewhere? Or you can address employment trajectories, how long before people get jobs, or spatial mismatch between where the jobs are and where the re-entering person lives. So there are a range of questions over there. It can also, I think, speak to some of these bias, what I described as kind of the extra legal factors that affect sentencing outcomes, about who gets mitigated departures, et cetera. You know, we look at that gender picture. You know, we say, well, okay, what are the legal reasons for that? What are the extra legal reasons, et cetera? So I think it can be used in many good ways. It's definitely not for use in terms of like, oh, well, we're going to go hassle these people, or we're going to, you know, include there are firewalls in place to protect that sort of information.
You know, it's the same questions that I think so first, like, we're in partnership with the commission here. So like whatever is mutually of interest is what we intend to study. I think it's just going to enable us to do primarily a better job isolating the effect of policy changes from like hard to observe characteristics of people. Because right now we can look and we could say, well, this person came in under a stricter guideline regime than this person. And we can imagine that they're the same on the things we can see, but they might be different in ways we can't see. That's one thing. Also, this opens up a lot of avenue to see the paths that brought people to this place. And you can see just in descriptive ways, like what share of people are coming from where and by what path are they arriving to MSGC's attention. And then in terms of outcomes, again, I think this is a very exciting possibility because, again, from MSGC's perspective, it's relatively easy to see public safety in the form of absence of reconviction, and it's safety in terms of they're incarcerated, but it's really hard to see the cost of that in terms of lost opportunity in the community, lost earnings, lost employment, lost education. And this makes those things observable in a way that you can't see right now.
Yes.
Just a little bit of a follow-up on this. To obtain this data, is it the same process as for under the Data Practices Act, or is it a little bit less? What is the process?
I'm not 100% sure how the data, I mean, it's all run by the state in accordance with all applicable laws. It's not just like a FOIA. It's not just like, we write a letter to an agency and say, give us your public data. Right. This is a much more tightly controlled, all the education data here is subject to FERPA, which is a federal education, HIPAA protects health data. Education data is very tightly controlled from the state and the federal level. So there's a lot of assurances and restrictions on how the data can be handled. So I'd say it's more restrictive than sort of your generic data request.
Yeah, I could add a bit. I mean, just having had a meeting about this with the SLEDS team, that they kind of asked the researchers, well, let's narrow your questions. Do you need all of these data to answer those questions? Because it's kind of a need to know basis. We're not going to just, researchers love it. We say, oh, just give us all your data and we'll do what we will with it. And so they pushed us there. And we were interested in kind of the school experience. How was your education trajectory? So we were matching with individual schools and then looking at things like Department of Corrections admissions later on, and to say, school funding, school segregation, those sorts of things affect. And so getting on, I just say we have to be much more precise than we've presented today about the specific project goals, but I think there is a compelling reason and state interest in addressing some of these questions. So I think we'd have a good chance.
We'll develop a draft application and we'll share that back and take feedback on that for sure.
I have one other, different topic. Back to the graphs on the three examples of the cases where there's these high departure rates, where the ones that are not mitigated, do you look at the time period for the entire sentence or just the amount of time that the person serves? So basically before they're released on supervised release or?
Yeah, if I understand correctly, we are examining their reconviction rate without adjusting for the duration of that sentence. So we're just looking at overall, how likely are they to be reconvicted within that long observation window. So that is something, though, we will be able to consider more fully. They're basically for lack of a better word, street time, how, right? And so how did that vary? And introduce that as an adjustment, but this is just the basic descriptive.
Okay, because that's what I was wondering, where it was the reconviction during
on all of those were 0. So I was curious if it was the time that they were actually, incarcerated.
Right.
Or if it included their supervised release time when they're out on supervision in the community.
Yeah, Nick can speak to that on each specific offense.
Right, yeah, so the way we did this was just, did they have another conviction after this first one that we're looking at? The first one being registration of predatory offenders. I mean, the first one that popped up in the years we're looking at. And then we're looking at whether or not they got a conviction, and then we would code it as whether or not that conviction was during the time they should have been in prison, right? Like if they got that mitigated dispositional departure versus not. So the orange so we would expect essentially people who did not get that mitigated, because these are presumptive cases, people who didn't get mitigated dispositional departure. The reason it's 0 down there is because they were in prison during that window, right? And then this is the orange is any time after that for both groups, right? The orange for either one, and then the people who fall in the green on the mitigated were just people who happen to be out during the time that they should have been, in prison per the guidelines.
Yeah, it gets a little more complicated with the durational departures, but we've also kind of coded that up to do this sort of analysis, the same sort of analysis. But excellent question. Yes, Commissioner.
Thank you. Could you just hone in for me, going back to the last chart with all the data available, how the Sentencing Guidelines Commission would use that to inform decisions about sentencing policy? I appreciate the ways that this data would show a lot of things about society, but what decisions does it impact for us?
Yeah, do you want
I can take that.
An example.
Yeah.
Dumb it down.
So, no, I'll try to be clear though. So like one example, the Sentencing Guidelines Commission sets the numbers in this grid, and says, if you're convicted of this type of offense and you have this criminal history, like we recommend this number of months for imprisonment sentence, or not, we recommend 0. And you have a choice. What should that number be? And over time, the commission has changed that number in various ways, like by adjusting criminal history formula, by reclassifying offenses to different severity levels, by introducing a new drug grid. So those are all policy choices that the commission has to make and makes, right? We can look in the past, there have been different policies for similar people, right? And so we can see the people who were subject to one number that was higher, a more punitive sentence versus a lower number, a less punitive guideline sentence. And we can then look out and we can say, the people who were pushed by the Guidelines Commission to be in prison longer compared to similar people who were pushed by the Guidelines Commission to be in prison shorter, what happened to those two groups? They're similar, they committed similar offenses, they had similar criminal histories. Now we can, with this data, we'd be able to say too, they're similar in many other ways in terms of their past, potentially. But we can then follow them out and we can say, what was their reoffense rate? That we can already do. But we could also say, how did their career trajectories differ? How did their educational trajectories differ?
After
sentencing. So we can say, the people who had the more strict policy, more severe sentence, if we go out 15 years, 10 years after their sentencing, maybe they had a 5-year sentence versus maybe the more severe one was 6 years and the more lenient one was 5 years. The two groups. And we can go out 15 years and we can see how much did the 6-year guideline group earn over the next 15 years versus how much did the 5-year sentencing group earn over the next 15 years.
Yeah, I'd add just maybe one of it is that, to me, it goes back to some of these principles discussions that you all have been having about just desserts, about public safety, about the rehabilitation, all of these big philosophical questions that Kevin and others have spoken on, and you're considering the review, that it can speak to those and really the public good. You know, so it's basically taking some unknowns and trying to make them, give us a glimpse into things. Well, we don't really know what happens to people at that follow-up. So that, if to the extent that that's useful information, the commission.
Is that clearer or?
And just thinking, so you're either going to say, okay, here are two different groups that were subject to one sentence that was higher, one sentence that was lower, and that difference on the box was a policy change. You know, afterwards, one group or the other had a better employment history, more earnings, or it's going to say, well, they were the same afterwards. It didn't matter.
Right, yeah, or exactly, yeah.
And
We
how
don't know
do you
the
know
answer.
that if there is a difference, it has anything to do with the number of months that their sentence was?
How would we know that?
Yeah.
The idea would be that because we understand when the policy change happened, we understand that the Guideline Commission changed its policy, you know, on this date. And we can see that these are similar types of people who are flowing into the system, you know, immediately before the change, immediately after the change. And we have to assume, so making that conclusion requires an assumption that there's nothing else changing that affects this group versus that group differentially. So like there could be things changing that affect both the same, but there's not some other change that would explain the difference. So you need to think about, like, was there something else changing in the legal system, something else changing in the sentencing policy, something else changing that, you know, was correlated with that policy change? That would be a problem. But if you can't think of something, and we need everyone's wisdom to like be sure that we're focused on a policy change that's not confounded with some other policy change.
Okay, the reason I don't want to say skeptical. I was a public defender before I was a judge. I worked with juveniles, and I think just, and this is not based on data, it's just what I knew and experienced for 13 years. If you had kids who were in a lot of trouble, committing very serious offenses, and we sent them to out-of-home placements and did not relocate them to home, but they ended up sort of relocated as a result of being college age, getting into schools, not going back to the old neighborhood, they did so much better. So there's a personal circumstance. How would that be reflected in this data? Do we know where they lived after they got out of prison?
It's a good question. I'm not sure if the system has address information. I have residential address information. It probably does if they're juveniles, like in the, because you know what school they're going to, so that would be a good proxy for where they live. But we can investigate that. I mean,
I'm just a little skeptical. I think these numbers would be good to say, you know, who ends up in prison? What's their background? I mean, that makes perfect sense to me, but I'm just a little less clear on how we could, with certainty, say a person's performance after their sentence is a result of a policy change that said it's a 5-year sentence instead of a 3-year sentence.
So, yeah, so it
We're
relies.
taking it on faith.
Well, it relies on the assumption that you know the policy change. You know that it affected this group, but not that group, or, you know, this subset of the grid, but not that subset of the grid. So you can look at changes among unaffected groups. You can see, look, over the same time period, this group was not affected by a policy change, and their outcomes, you know, drifted up. And then you can look at the group that was affected by the policy change, and you can say, did their outcomes drift up the same amount? If so, the policy probably didn't have much effect because there was, no difference. There was no difference in the change for the affected group and the unaffected group. To think that this isn't going to be informative, you have to have some story in mind about something that changed at the same time as the policy, that affected the same group as the policy, and didn't affect others. So it is hard. You should be skeptical. We should all be careful in interpreting these things. And I'm happy to talk more about the research design.
And then just a technical, the first line is ACT. That's literally your ACT test. So because somebody has ended up in the criminal system, you can get access from the Department of Education to their ACT score?
No, this is true for all Minnesota students.
It's just linking. So they have all the ACT scores. We have a group of people, if they had an ACT score, we would be able to link that to their data set.
Do the parents of these kids know that you can get their test scores? I'm actually
gonna cut this conversation. We're getting a little too far in the weeds and we have to keep things on track this morning. So I think that there could be more conversation offline if you have questions there, but I thought there was maybe one or two more questions.
I can wait. I did have some questions about the slides for some clarification based on some comments Commissioner Middlebrook made, but
on the findings slide?
Yes.
Go ahead and ask that, and then did you, okay,
So
there was two more questions, and then we'll.
So the slide that had the first severe conviction slide, I think that might have been the felon in possession grid. And I just wanted to clarify based on question Commissioner Middlebrook asked in the answer, because it's different than how I was reading that slide. So on the mitigated or the not mitigated, next,
one?
the
Possession of.
Keep going there.
Next. That one.
Yeah.
So the not mitigated says to me that person got the guideline sentence, went to prison.
Right.
So any reconviction during wouldn't be like on supervised release or in prison. It would only be after they were out. I mean, that's what I'm trying to figure out. So
Yeah, I would say it's not always zero because there are offenses that are occurring in prison.
Yeah.
So it's small, but Nick, you could give a little more on the specifics.
Yeah, I mean, kind of the point you just made. Those people can't have a green bar on that group because they were in prison during the time that the guidelines said that they should be in prison. The only reason the other group has that green bar is because they have a period of time, and it varies from person to person depending on the offense and where they landed on the grid, where they were not in prison when the guidelines said they should have been. So the orange bars are any time. The time that this graph stops would be whenever anyone commits that second offense, right? So, but the orange ones is just, did they commit it, in a time where they weren't supposed to be in prison per the guidelines? So that's why,
And just generally, the reason why I was asking this question, because I do think it's a query question for us to be thinking about later as we've done our policy change regarding length of probation. So if somebody gets a mitigated departure, they're on probation for a long period of time, and they come out and they're on supervised release and they are under sentence still, and they commit something, but that supervision is less time. I don't know what this means, but in my head, there's something telling about people who are doing something in this shorter period of time that we're looking at versus periods of time that we're looking at that are longer, and if there's a correlation between the types of offenses and the kind of violations or the kind of convictions. And so again, I'm throwing that out there for sort of further discussion, because as I was looking at these graphs, I was thinking about supervised release and being supervised for short periods of time and committing new crimes versus a 5-year probation that you get on a mitigated sentence, so you're being watched longer. What are you doing? So I think there's something there, I don't know what, but it's an interesting sort of correlation.
Okay. Yeah.
Excellent.
I have two things. One is actually, if you go one slide before this one, I would love to know what the breakdown is, the connection with the firearm, and is it tied to domestics? Is it tied to like drug violence, I would love to know what the connection to the firearm is. And then in regards to thinking about bias, is it possible to get data around who's making the decisions to be able to compare that to the folks that we're talking about?
Judges.
Like judges, probation officers, yeah, attorneys.
Yes.
We have judges, yeah.
Yeah, I would say we don't have a lot of cases per judge, so judge effects are like, would be more of an adjustment factor for us down the road. Like we can do that, but but those data are knowable. Yeah. And on all of this too, just the big question is, I think about this too in terms of my anecdotes or what I've seen in the field. And I was looking at this last night and I was saying, well, gosh, I have somebody who got a mitigated departure and then attended the University of Minnesota, and now he's a famous professor. I also have somebody who got a mitigated departure, and then 20 years later, he killed somebody. And so I've got both of those in my head, and I'm trying to use whatever skills I have or don't have as a social scientist to figure out, okay, well, what's the prevailing pattern, or what kind of things are repeated, and how so. Both of those, like when we talk about ongoing research, those are driving kind of our questions, and our desire is just to improve our knowledge of those a little bit, to open that window up.
All right, well, thank you very much.
Thank you.
Lots of food for thought today. I really appreciated all the work that you've put in here. We're gonna go ahead and take a break. I'd like everyone to come back by 10 minutes to 11, and then we will keep going with Matt. So creaky.
Is Go Big Red from Highland?
Huh?
Is Go Big Red Highland?
This is Nebraska.
Hey.
The top of that. I can. Yeah.
All right.
Actually, I didn't know that. Okay, all right, we're going to come back to order now, and the next item on our agenda is a presentation by Matt on the stakeholder engagement. So I'm going to hand it over to Charlie and Jonathan.
Thanks, Chair Mitchell. So, we're here from Management Analysis and Development, or we affectionately call ourselves MAD. So we've been your partners on the public engagement and practitioner engagement work over the past several months, and we're really glad to be here to check in with you, share what we've been hearing, and get your feedback and help make meaning of the information we've heard. So I'm Charlie Selu, with my colleague Shamsa Dayo. We sit within a state agency, Minnesota Management and Budget, but we are facilitators, engagement practitioners, consultants who work across state agencies. So we're not subject matter experts, but we are really excited to be able to bring kind of the public and practitioner voice from the sessions that we've had. All right, so our goals for the sections that we have today are to help you all can get into the data and the feedback that we've heard. We've been spending the past several months in listening sessions and talking with folks, and we want to give you all time to really digest some of what we've heard. And so that's kind of our first main goal, is just to help you make meaning of the data that's been gathered during this first phase of engagement. And then as we get into the afternoon, we'll want to work together to identify what are the areas that are priorities for you, what are the important challenges and areas for change that you want to explore together in the coming months, and then get your direction on, in order to do that, what further engagement do we need to do, what research questions do you have for the research staff, and kind of how do we learn more about the topics that you select for further exploration. So just in terms of the agenda, of kind of our parts of the agenda, for the morning, we'll be sharing out about the process and approach we used for engagement this summer, and then share audience by audience what themes we heard. And that's where we'll want to bring you into conversation about, we'll share some of the themes that we noticed, and we want you to also help join the conversation of what themes stood out to you. Then The next part of this slide is all going to be in the afternoon. So we'll break for lunch after we have some other presentations as well. And when we're back after lunch, we'll share out some of the general themes and tensions we're noticing across audience groups. And we'll ask you to reflect together on the themes you're noticing across the different audiences that we heard from, but also across the different research and other presentations that you've had today and in recent months. And then we'll kind of converge downward on what are the challenges and areas to address, as we talked about, and then those methods of how are we going to learn more. Just in terms of where this fits into the arc of MAD's work with MSGC, we are in this October window where we're presenting the findings and designing follow-up activities based on the earlier engagement we did this summer. We then have a window this fall and winter to do follow-up engagement, and we'll write a final report next year. And then one final thing I wanted to mention just at the front was when we were back with you almost a year ago, we met and talked about kind of what are the objectives for the comprehensive review. So I wanted to reground ourselves in what those were, and I won't read through all of these, but just wanted to highlight there were values here around transparency, around making things easier to understand and use, and then also sort of like outcome goals of leading to an increased public safety, about consistency, about being proportionate and fair, and avoiding disparities. So those are based on the conversation that we had with you about a year ago when we were embarking on this work. So I'll hand it over to Shanta to talk about our engagement approach and process.
All right, so as Charlie just mentioned, we talked about the values. So as we are going through this part of the presentation, I want you all to remember the values, as well as when we go through all the different audience groups, there are going to be a lot of contradicting statements. So this is what we are here to do today. It's going to be a difficult conversation, but buckle up for the ride, I guess. All right. So we had two different sessions, or two different approaches to our sessions. So the first session were for the practitioners, and this practitioner sessions were structured as a listening session format with both written comments and discussion, which allowed the practitioners to have individual reflections as well as have conversations or discussions with their I guess, colleagues in the session. In each session, we had two facilitators, one facilitator who was making sure that they went through the whole session, and then another one who was taking notes. And then we also made sure that we recorded every session so that we were able to capture every single note that the practitioner was saying. And then for the public group, we had case study sessions for those without direct exposure to the guidelines. And we used case examples given to us by MSGC staff. There were 3 case vignettes given to us. One was for drugs, one was for unwanted person, and one was for burglary offenses to identify and explore principles that are held by the public and embedded in their attitudes towards sentencing. As we were trying to figure out the structure or the methodology for the public sessions, we actually came across a lot of different research that were done by Professor Fraze and as well as other professors in the room here with us today. And we designed to capture community perspectives of experiences and concerns about fairness, equity, and justice. In the public sessions, it was 3 parts. So the first part, we gave case vignettes and then asked the participants to give us their, what would they sentence this individual, given the information. And then part 2, we gave them mitigating and like aggravating factors, and then asked them if their answers from the first part has changed based on the factors given to them in part 2. And then in part 3, we were able to give them the actual sentence given by the judge, and then we're able to get their reaction from that.
And just to note too that we, in that format of what we're mostly calling the public sessions, we also included some practitioners who had less direct exposure to the guidelines. So that included the treatment and rehabilitation services practitioners, kind of got that case study format.
Right. And then for the practitioner listening sessions, we also came across the Moss group, which was DC sentencing guidelines. They had a focus group. We actually kind of also took some of their, incorporated some of their pieces as well too. So the topics we covered for the practitioner sessions were the sentencing guidelines grid, offense severity groups, criminal history scores, sentencing guidelines manual, and other challenges. The questions that we asked in that session was, what do you want to make sure remains in place even as the guidelines are updated, and why? And the second question was, what are the challenges? What is the challenge with the current sentencing guidelines and why? And then what solutions can you offer for each of the 5 different categories I just listed off?
Question.
Commissioner Larkin?
For the aggravating and mitigating factors or otherwise, for the sample scenarios, is criminal history or lack thereof a consideration?
In, I think case 2, or actually, yes, case 2 and case 3 both factored in if the individual had previous criminal history scores, I guess, previous sentences, right?
Yeah, it wasn't just framed in terms of criminal history scores or like overall history. It was more looking at our materials. It was more framed as the actual offenses. For example, in case 3, which was the burglary case, we said the suspect had a prior felony conviction for secondary burglary in 2017. And we mentioned these just to note too that because we chose these 3 offenses, we got more feedback on these topics. So we kind of, it made it more tangible, but it also kind of shaped the conversation that we had.
All right. In terms of geography, we divided up the geography based off of the judicial districts. So we had 2nd and 4th district come together as Twin Cities, and then the 1st and 10th as suburban metro. We had the 1st, 5th, and 3rd as South and Southwest, and then the 9th and 7th as Northwest, and then the 6th district as Northeast. Based off of our data, we heard back from about 81 practitioners, and then about, I'll come back to that. But majority of our participants were from outer Twin Cities area.
Excuse me, you didn't say the 8th. Which group were they in?
The 8th was in South and Southwest, so 3, 5, and 8. So 3, 5, and 8 had 26 participants from the practitioner session. 2 and 4, Twin Cities, we had 4 participants from the practitioner session. 1 and 10, suburban metro, there were 21 participants. And then in Northeast, which is District 6, we had 10 participants. And then 7 and 9, Northwest.
6 by themselves?
Yeah, 6 by themselves, yeah.
Thank you.
And that cuts across all the different practitioner groups, right?
Yes.
So, yeah.
Yep.
And then 7 and 9, Northwest was 42 participants.
So I assume you sent this out to everybody, so whether or not you had people participating was up to them. So, because I noticed like for the prosecutors, you don't have any from the 4th or the 2nd. That was their choice?
Yeah, so what we did for the practitioner sessions, we reached out to all the different associations, the head associations, and we asked them, based off of the geography we have here, making sure that we capture at least 1 participant from each geography. So in the prosecutor session, we had 2 sessions. The first session captured, I'll come back to that at the end. But yeah, for the practitioners, we made sure that we reach out to associations in order to get all the participants.
We didn't have like a list of every prosecutor, and so we used those kind of associations. And so the intent was that there was a broad ask. But yeah, we didn't, to your point, we didn't reach every practitioner category in every geography. And I think that's a notable one of, we didn't have Hennepin or Ramsey County prosecutors.
Same for the public defenders, defense attorneys. There was no one from 2nd or 4th.
We had one from Ramsey County, but we didn't have one from Hennepin.
It's not listed. It wasn't listed on. The first district was, but not the 2nd.
for the.
Yeah, I think there might have been
Oh, I see what you're saying, yeah. So we had suburban metro, but not, so we had Twin Cities, but we didn't have Hennepin and Ramsey counties.
Right.
And I think one caveat there is because when we were doing our regions in this map, we were doing it by judicial district, not by county. But are they the exact same?
Yeah.
They are the same? Okay.
But then also, what happened was when we first reached out, we noticed that we didn't have anybody from Hennepin and Ramsey. And then at the end, I believe the head chief public defender of Ramsey ended coming to the session, if I'm not mistaken.
We can follow up on that, whether we actually who and how, whether we got the public defender from Hennepin and Ramsey. The other factor that was a little bit confusing maybe in these sessions is that we also had a survey. So some people responded via survey and not via the session. So that could be the other factor that, so for example, you notice on the public defense or the defense attorney, there's like the two additional survey respondents. We can look into that and see whether that was also.
In terms of our data collection and analysis, so in our practitioner sessions, we use Padlet, which is a tool where practitioners could actually submit their comments written. And then after they've written their commentary in each category, we had discussions. And then we also had post-session surveys as well as open survey, but we realized that with the surveys, we didn't get a lot of responses. And then when it comes to analysis, we partnered up with MSGC staff to help us explore our findings or our feedback from the full sessions.
Other question, I know we had, any other questions on approach and process before we dive in?
I have one question. So I don't think I've seen the survey. I know that was put together with staff. Would we be able to see the surveys that went out?
Yeah, absolutely.
And what was the format of that? Like,
Can you see more
was
about
it online? Like,
yes, it was online in it was mobile responsive though, so people could have taken it on their phone.
okay.
What we did, as Sean was mentioned, we didn't have a great response rate. The intention was that after a session, if people had, because some people are slower or faster to process information, and we wanted to provide an ability for people to add additional comments after the session. And we also wanted to capture more demographic information about the participants, but we had a fairly low response rate of the people in the session actually completing that post-session survey. And then we also had a survey that we used for people who weren't able to attend a session. But our recruitment was really focused on the sessions. We weren't necessarily trying to widely promote the survey. It was really an alternative to the session. So the questions sort of were designed to capture similar forms of input, but happy to share it.
Did it make, I guess, my ultimate question is, does it make sense to combine the results of the survey with the discussion that you had in the in-person sessions? Like, did you ask the same questions, solicit the same kinds of comments in the survey as you would in an in-person session?
That was the intent. So for the post-session survey, we actually explicitly repeated the questions and said, is there anything else you have to add on the topics that we discussed? But there were some additional demographic questions to try to capture where people were in the state if it wasn't already known to us.
Okay, thank you.
And I'm not sure that we have this, but in addition to the survey questions, could we get the case scenarios that were presented to people?
Yeah, we can pass those out too.
I think I have it. Thank you.
Yeah.
We'll pass those out during the discussion for the themes for engagement by audience. And I apologize, there was a lot of information, and as researchers, but we're consultants, so it's like how much information can we put on a slide? And then also how much should we present to you all and how much do we allow you all to discuss in order to move through the day today. But I'll pass out the cases for the public sessions soon. All right, so ahead of our October 10 meeting, we shared out the engagement snapshots, which summarizes input from engagement sessions by audience. We asked each commissioner matched each commissioner with one audience as a primary reviewer where applicable. These assignments were based on professional and personal connections commissioners have to that audience group. And then for the judges, because we weren't a part of that session, we weren't able to give the judges an assignment for them.
Well, judges had random assignments. So
Yeah.
normally the commissioners are assigned to an audience that you are associated with. If you don't have that audience, including the judges, because we didn't do a judicial session, those were assigned randomly. And then one other note on the process for law enforcement, that was only survey based. And so that you'll see that different when we get to that audience group.
All right, so for the process today, we'll have a conversation about what we've heard from each audience, starting with the two commissioners assigned as primary reviewers for that audience. As a reminder, the guiding question for each conversation will be, what themes stand out to you from this audience?
And just a note too, I have the unenviable job of trying to manage our time in this today. So I'll try to guide us as we have discussions to make to the next audience. So apologies in advance.
All right, so the first audience, correction and probation practitioners, the primary reviewers here were Commissioners Latoya Reeves and Commissioner Kelly Mitchell.
So just as a process step two, you should have in your packet a copy of all of these if you'd like. And so I imagine that it may be helpful to pull out the snapshots as we're talking about them.
Oh, just a copy? Oh, okay.
So before we go ahead, I just want to make a note, the bullet points we have on the left side of the screen are the key themes from the audience, and then on the right, we pulled out actual statements that we heard from the sessions. And for the corrections and probation practitioners, we made sure to get feedback from all three different correctional delivery systems. We had about 5 sessions in total, 3 for DOC, 1 for MACCAC, and then 1 for MACPO.
You want?
All right, so question again is, what themes stand out to you from this audience?
So I'll start with, I look at what the practitioner said of departures, in particular immutability. I thought that was very interesting. Commissioner Frey kind of brought it up today. What does that mean in terms of how departures are being handed out? Is there disparities in particular immutability? I thought that was an interesting comment that was made. I do like the comments about the different grids. I definitely respect that it is much easier to do. I have notes all over the paper here. Applying uniform probation caps across the offenses, it seems inadequate. I don't agree with that comment, but that was interesting that was said. I think uniform probation caps makes it easier for us because we see that some people have much longer probation sentences previously to the law change. Someone made a comment that the failure to register or firearm possession weakens the guidelines authority when they bypass presumptive commitments. Thought that was an interesting comment. The half point they found is meaningless. I agree with that. It often rounds down to 0, very ineffective. And then the discretion given to courts to waive custody points leads to disparities across counties. They should not be able to waive that. I thought that was very interesting.
Can I interject here real quick?
Yeah.
I want to be able to make sure that you all both have a conversation.
Oh,
so
okay.
let's give a chance for Commissioner Mitchell to also respond back to some of your comments.
Were you almost done anyway?
Pretty much, go ahead.
No, actually, some of the same stuff that you said is what stood out to me. Like, it seemed like this group liked the fact that there were separate grids for different types of offenses and that made it easier. So that stood out to me as well. There was some support here for keeping guidelines, keeping determinate sentencing, just having that certainty seemed to work for this group. But they think that it's too hard. The guidelines are too complex, and I think that the area that seemed to really stand out to this group for trying to figure out the guidelines was those out-of-state offenses where they felt like they needed to be lawyers to understand how to bring those into the guidelines.
That doesn't help.
Being a lawyer.
To that point, the lawyers also said the same thing too.
Right, right, yeah, I actually started this other document where I was like, actually, everybody said these things.
Yeah.
And that was one of them. That was one of the things that I thought was really, really interesting. But then it's interesting, did you pick up, like, I thought that this group said the departures are becoming too common. And so that was also very interesting to see that comment.
It is very interesting, especially when it comes down to probation resources and staff and caseload size. As I kind of went past this conversation to say, with all the departures, the caseloads that used to be 40 to 1 are becoming almost double in some instances, especially if you talk about high contact, which the county does, they go by different contact levels in terms of how they assign clients. So that was very interesting. What do you think about the ensuring modifiers that explicitly stated in complaints to avoid confusion? I was like, yes. I really like that. If that could be something they can work on as well.
Some of it seemed to be technical stuff that they're looking for that I think could be clarified in the trainings and how guidelines are, how people learn how to use the guidelines, like in those forums. I think some of it is like stuff our staff can help support changes in making sure that stuff happens.
Probably more frequent trainings and guidelines.
I think Commissioner Fraze wanted to say something.
Yeah.
You may have covered this, Mr. What was that first quote there, the different languages? What do you think the respondent was getting at?
I think you're referring to the manual in part, right? Or what do you all make of it?
There was comments in here.
This was the most simple statement out of all the statements that said this is too complex for us. Yeah, so they're particularly talking about the manual itself. Yeah.
They wanted more description instead of referring to like this code or this number or this chapter somewhere down the line.
Specific, yeah.
They wanted more detail for these things here, so. I really like the mandatory ongoing training for judges, attorneys, and supervision practitioners. That would really be helpful. Some of the counties have changed their model in terms of who's actually doing sentencing guidelines worksheet. They're more focused now and have been towards the PSI units and the pre-adjudication services. So some of the other agents aren't getting as much practice. And so when they have to pop up and do one, it's taking much longer to get one done. So ongoing training would be very helpful.
Let me interject again one more time. Does anyone else in the room have anything else they want to say or add as you hear both commissioners discuss this? No, go ahead, yeah.
The last line under correction and probation practitioners. Participants observe significant disparities in sentencing practices across jurisdictions and racial discrepancies in sentencing outcomes, suggesting that this is more a result of prosecutorial practices than the guidelines themselves. I thought that was a very interesting comment. I agree with that in terms of circumstances. So that's pretty much my notes around.
Thank you. Commissioner Mitchell, you have anything else to add?
The only thing that we didn't say that stood out to me was the comment about unranked offenses. Like I'm getting it, not just in this one, but across a couple, like people really hate unranked offenses.
Yeah.
So maybe we should do something about that. Yeah, that's about it.
Were there any questions that raised for you all? And this is for everyone.
Including like questions for follow-up engagement or research, like things we need to like learn more about.
I have a question about that specifically related to unranked offenses. So as I'm now a defense lawyer. That is a really huge issue for me in state court, which is very different from federal court. And I'm curious for probation officers, do they feel equipped to be, if we went and limited the number of unranked offenses, where we provided a severity score to each offense, would they be equipped to, I guess, handle the differences in severity among offenses? Like I'm thinking about property crimes and crimes that involve money. Right now, I think the guidelines only have one dividing line for loss amount. Are state probation officers equipped to draw distinctions between defendants that are involved in crimes that involve like $10,000 versus $20 million? Because from my perspective, a lot of the unranked offenses are offenses that involve monetary losses. And I know in federal court, there's a whole apparatus for addressing monetary losses, and there's many more dividing lines between different loss amounts. I don't really see any of that for state probation officers, and so I guess I'm just curious, do they feel like they would be able to handle writing PSIs if there were a lot more offenses to rank or a lot more severity levels in the guidelines?
Across all sessions, I also want to hear your perspective on this, but across all sessions, from what I'm gathering is that probation officers feel like they are unequipped, nor they feel like this should be a part of their duty because they don't have the legal expertise. And they feel like they have to keep going back in between MSGC and then judges in order to figure out what is the right thing to do. And then also the fact that it is also affecting their supervision role as well too.
And partly that was a original workload thing too.
Yeah.
What's the impact of the errors in the worksheet on time served?
That's kind of like a research question of like how to.
Yeah, I don't really understand the worksheet situation. But there's a lot of notes about errors in the worksheet and incorrect information. I'm just wondering, like, is there a correlation between that issue and the outcome for the offender?
Oh, yes, and Lord forbid it's something that's significantly wrong, where, for example, because you have probation instead of a prison commit. And can you imagine how the agent would feel if they made an error that sent someone, that has happened unfortunately, where an error was made that sent someone to prison when they actually should have been on probation, and they had to re-sentence the person. So you definitely don't want an error on the same time. Hopefully it's not that prevalent, but it has happened. I know it's happened in the county.
Yeah, it was mentioned
in
all, at least one person mentioned that in all sessions.
So, I mean, I'm going to defend the guidelines and say, in my experience, many of those errors are because the worksheet was not done before sentencing.
Oh, for
So,
sure.
Yes,
For sure.
yes.
For sure.
I would agree with it
And
wholeheartedly, yeah.
just in terms of providing context, our case law says that an incorrect criminal history score is illegal and can be challenged and fixed at any time. So I know, you've got an extreme example there, but we see lots of appeals where the issue is my criminal history score was wrong. And it's not necessarily probation's fault. If there's a defense attorney, the defense attorney should be checking, making sure the prosecutor should be doing it. There's a lot that goes into it, but when it does happen, it doesn't matter how long afterwards.
Right.
When somebody raises it, the court addresses it.
Okay.
And
Is
we
that
heard
part-
out-of-state convictions, that's something that the judge brought up, because that's a mess to deal with, but that is one that results in a lot of reversals.
Right, but the thing is, the sad part about that is,
Or
it wasn't supposed to be incarcerated, was based on an error.
Yeah.
And whatever the error happened, I know some counties do it differently. In Hennepin, for example, we do a criminal history, a criminal record summary ahead of time that gives an idea of what the sentencing guidelines worksheet will look like when it's sentenced. And then we will either do the sentencing guidelines worksheet and then have it ready to go at sentencing, and then they just kind of hit the button just to make sure everything was the same. But I know other counties kind of do it a little bit differently. They do it just differently than Hennepin. I think we're kind of our own little deal when it comes to criminal record summary. But that criminal record summary gives us an idea, obviously, so they can negotiate off of that. So it's going to be present to commit, probation. This is what the time would look like based on the sentencing guidelines, all that's on that one document before it even gets to the worksheet. But an error, you just don't want to error. Nobody wants to error. Even if they can appeal at any time, you would feel bad that if while you're looking at it, not doing due diligence, double checking, triple checking, 5 times, 6 times, because sometimes you feel you gotta do that, then you gotta make sure it's correct.
All right, for time purposes, we're gonna have to move on because unfortunately, and that's why I'm a little frustrated as well too, we have to go through all this within 1 hour. So the next audience, public defenders, the primary viewers here are Commissioner Catherine Middlebrook and then Commissioner Brooke Larkin. Same question. What are the themes that stood out to you from this audience?
Want me to start? Sure. So I think that a lot of the same themes that came through from probation and corrections came through with the public defenders, defense attorneys, and the legal aid providers. The one theme that I guess was noted was that the guidelines are too punitive. And I think that goes to whether or not they're in comparison to the same crimes in the same severity level, more so than overall. And then also that they're, in that sense, they're disproportionate. One other thing that came through was that they valued the ability for downward departures that would take into account the mitigating life circumstances of the defendant. Again, another theme that came from the previous group was that they wanted additional training and education for practitioners and educating the public. I think that they also appreciated the separate grids because they are, and I can vouch for that they're really easy to show a client where they fall when you're talking about what they're looking at for a sentence. So they think that was very, they're easy to use and to be able to figure that out. They like the separate grids for the sex offenses, drug offenses, and the standard grid. I think one of the main things too is that they really are, looking at the bigger goal of reducing disparate impact across many different areas. So those were, I think, a few of the main things that I took out of there. You want to add anything?
Sure. Things I saw were a general desire to reduce sentence length, pointing out what reasonably could be perceived as illogical rankings in terms of severity level and public safety. Examples where you could say, well, are we really more concerned about this third-degree drug possession or this other assault where someone was actually physically harmed and they're ranked in reverse of what they possibly should be. So that was useful. And then the third thing I'd say is sort of this internal conflict sort of undermines all of our discussions, in my view, where they favor the sentencing guidelines for consistency in sentencing and outcomes, but they want departures to recognize individual circumstances, which is sort of inconsistent with the notion of treating similarly situated people similarly. And they don't like the presumptive sentence range in the boxes because that gives a judge too much discretion, even though it also gives a judge discretion to sentence at the low end. So I think some of the things the public defenders have pointed out are just reflecting that conflict that we always have of maybe you can't have it both ways. You can't ask judges to use discretion based on individual circumstances and at the same time want everyone treated the same.
We're also going to be making some of those notes later on in the afternoon session when we talk about the themes and the tension between across the different audience groups.
And within them
as well too, yeah. Does anybody else want to offer any other commentary?
The only other thing that stood out to me was this sort of explicit, somebody, at least one person said they're looking for additional guidance on when judges might consider granting a stay of imposition over a stay of execution. The guidelines are silent on that right now. So I thought that was interesting that they were interested in guidance on that.
The next audience group is the prosecutors and county attorney staff. The primary viewers here are Commissioners Ladd and Knudsen. Same question, what themes stand out to you from this audience?
I'll take a stab at it just generally. I was an overachiever. I read them all. I wanted to see what everybody had to say. And I will just say one of the themes that, and I kind of took a larger approach as I was thinking about this. One of the things that I saw was there seemed to be between prosecutors, law enforcement, victim advocates, and the treatment providers, and even the formerly incarcerated persons, there seemed to be somewhat of focus or mention or contemplation of victims. And it seemed like on the defense side and from corrections and probation, that wasn't the theme. No, I cautioned my comments with, I don't know exactly what the framework was of the questions and these case studies, but I found that interesting that the victim piece of that was noticeably silent in those other two groups. And that was an interesting observation from my perspective, not just as a prosecutor myself, but from the various other groups and sort of how they tackled these questions. And so that was a big thing for me, was sort of having a victim focus as part of all of this. To echo Commissioner Larkin's comments in this group, I think similarly, there's this tension between having uniformity and not disparity in sentences across the state. But how do you do that if you have hard line guidelines that you gotta see in these boxes without giving some deference to the court and that sort of thing? And one of the things I was talking with Commissioner Knudsen about, there's so much subjectivity in this, starting with policing practices, like, and how you finally get to, like, even a prosecutor's desk. So for example, you've got city police departments, you've got sheriff's office, you've got state patrol, and they make policing practice decisions about who are they having contact with. Then you have the prosecutors involved, and it's like, I don't know if any city attorneys were as part of this, but city attorneys come into play here because of how the misdemeanors and the gross misdemeanors count for units for points for criminal history purposes, and what their prosecutorial practices are. And then enter 87 county attorneys, and without mentioning any names, there's practices within county attorneys' offices that says, we're not going to charge out these types of crimes unless they meet these sorts of thresholds, even though they're crimes, right? Mm-hmm. That might be over here in this part of the state, but over here in this part of the state, everybody's prosecuting that. And so before you even get to a point where you're looking at sentencing, you've got all of these sort of pieces that are subjective within these groups. And you got probation weighing in on stuff, and we've got 3 systems. And then I'm not even going to talk about the 296 judges that we have that kind of come into the mix. So as I'm looking at all this, I just sort of see that there's this want for uniformity and clarity and simplicity. But I think there's also a recognition that of all of these stakeholders, it's a difficult challenge to sort of get to that goal with all of that. So that was my overview.
Yeah. Well, in general, everyone says the grids are good. You know, even with the expansion to 3 separate subject matters, everyone agrees that the grids are good. They're simple. They're easy to read. They're easy to explain. One thing I didn't think about it was one of the comments was the prosecutors, they need to be able to explain to the public why and what and how and what to expect to victims, to their cities and to their counties. So it does need to be simple, it needs to be understandable, and sometimes it's not. So major themes, the commentary needs to be rewritten, reorganized, it needs to be clarified. And we all can understand how that commentary developed. Every time the legislature meets in session, we have to add and change the commentary. And it's hard to find things. Even yesterday, I asked my law clerk, I'm in the middle of a sentence, I said, can you quick look this up, find this out? He says, can't find it. Finally, I just looked it up and figured it out. But it's hard to find stuff in that commentary. And some of it's hard to understand. The half point is a discussion and is a thorn in people's side, I think. Why is there discretion? Why can you waive it? Why do we have the half point? It's too complex, and then either counts or it doesn't count. So again, simplicity is important. What do we want to exchange or change about the guidelines? It's, you open up for this participation. It's very interesting, the comments that you get about what can be changed or what they think can be changed and different ideas and pretty imaginative at times.
Well, we are a creative group.
Yeah. So too many departures, too lenient, the guidelines are too lenient, some of the comments are. Difficulty for prosecutors of the border cities, the discrepancies between what we do in the state of Minnesota versus what's happening in the border cities. That's a difficult issue for those prosecutors in those outlying areas to deal with. Suggestion the grids could include collateral consequence notations. So this offense will lead to these collateral consequences. I don't know how exactly that would be communicated, but it's an issue that people have to explain to them. Severity groups can seem arbitrary. That was a comment earlier. Some of the severity levels are too low in relation to others in that same level. Again, criminal history scores, custody status points are a problem. Misdemeanor, gross misdemeanor points. And again, that manual is complex. The other thing is training, and we heard that from the judges too, that Judge Larkin.
On that comment.
Concern about victim rights and input, but recent discussions, I guess, from the guidelines commission maybe, or in general, seem to be more focused on offenders' rights or interests. And just good comments about addressing and looking at disparities. And what factors in these disparate departures.
Any follow-up commentary?
I thought it was interesting when it said desire to expand the grid to offer longer sentences for people with higher criminal history scores. And there's a comment about a score of 20 is different than a score of 6. Yep. And I thought that was an interesting comment and what that would look like potentially going forward. I mean, 20 is very different than 6. But on that grid, I just stuck with the top of the box. So it was interesting for that comment.
Yeah.
I mean, they did also bring up the federal guidelines and they said they don't want that much, but something between.
Something, yeah.
Yeah.
It's federal.
To me, this was also the third, since, all three of the feedback groups up to this point talked about specific instances where there were offenses that seemed out of whack, severity level wise. So to me, it was like, okay, maybe we need to do like a more thorough review of where offenses are ranked and see how those differences jump out, or are there things that, really are jumping out as like over time we put them on a line and maybe it doesn't make sense anymore.
Yeah, and across different audience groups, that was mentioned as well too. Like re-looking at the offenses and re-ranking them.
I think to Commissioner's point, the Sheriff's point, especially about the vehicular homicide. That's been a conversation. Can you rely, especially after the case over in South Minneapolis that's been coming up from the news? And then they have a comment here about identity theft should not be higher than vehicular homicide, which is point well made. So,
thank you. All right, we're going to move on to formerly incarcerated people and advocates. So this is the public cases. You want to pass this out?
Pass this out. So I'll just pass out the your one refer to what the participants in these sessions saw. They didn't experience it exactly this way. It was more in like a PowerPoint format, but.
So we originally got these cases from MSG staff, so thank you all for that. And then we, for the layman people, we try to reduce the language and try to make it really simple so folks in the sessions could grasp the case easily. All right, so the primary review for this audience group is Commissioner Moran, I believe he's not here, and Commissioner Fraze.
So Commissioner Moore is not online either.
There's no online today.
Yeah, okay. I didn't prepare to be the primary presenter. So I will walk myself and you through this report. Not some of the key things are not.
Can you speak up? It's really hard to hear you. I'm sorry.
I'm sorry?
Can you speak up? It's really hard to hear you.
Oh, okay. I hear myself fine, but then I have hearing aids. And they're turned up high. So I'm just going to walk through the key themes and some other notes I made going through this report. I think some of the key themes are not too surprising for people who have received prison sentences, about, too much focus on incarceration, not enough on root causes, but also repair the harm. So that and a later comment on focus on crime's impact on the victim, I thought was very interesting, that the offenders were volunteering that. Now, I guess if you had some time to think of, reflect on your sins, we would hope that they would at least develop that perspective if they didn't have it already. A few of them. Now, one of the general problems I mentioned here is that this, so this is based on 23 people who came to the sessions, which is, the second highest number in this group, so that's good. But still, they're, as I think was brought out before, they are not a random sample of constituencies and are self-selected. It would be interesting to know, but I don't know if you have this in the data, which of the people who specifically mentioned preparing harm or the crime's impact on the victim have been through some sort of restorative justice process, which is, I think, my impression. I no data or expertise on this, but I would assume it's exceptional. I mean, there are such programs, but that most offenders, maybe especially those who go to prison, have not been through this. So anyway, that kind of jumped out at me. I guess in terms of the specific cases, there's a lot of, as has been pointed out before, there are a lot of interesting similarities and themes across these constituencies about, what's sentence too high, what's sentence too low, drug crimes too harsh, person crimes too lenient, I guess property crimes, what did this group say, too harsh. So, I mean, I think that, to me, that's the very interesting takeaway, and it helps to counteract the problem of low numbers and self-selection. If it's what one of my professors called triangulation of proof. Each source of information has its limitations, defects, but if multiple sources are telling you the same thing, you may be actually measuring something real. I guess one question I had, I didn't see it here, and haven't heard or seen it in the other reports, is the third step in this, after this, with the three cases, was to tell the people what the actual sentence was in that case. And I guess I'm curious what their reaction, what differences appeared here or in other constituencies. I mean, my impression, but again, no expertise in this area, is that when you ask people to sentence cases with limited information, you get one set of sentences. You give them more information, step two, in your process, they give different results, often less severe. And then when you compare what their sentences are to what judges actually do, and they will tell you, oh, sentences are too lenient, But sometimes the people, the respondents are more lenient than the judges are in these cases. So I don't know, and just to take this constituency as an example, how did the sentences, step one, step two, compare, and how did those sentences compare to the actual?
Before I go ahead and answer any questions, does anyone else have any other commentary or feedback or theme that they want to point out for this group? Go ahead.
I just had one that was, when you talk about inconsistencies being brought up and all the different, I thought the fact that offenders said that inconsistencies, they should call it painful to see different sentences for the same, and they worded it as, you know, why does their life matter more than mine? And I thought that was, you know, you forget about that, we're talking about practitioners and the inconsistencies there in the view, but the people that are incarcerated probably feel that inconsistency more than any of us.
Yeah, especially if you're sharing a cell in the same block with somebody from somewhere else in the state, and you know you are both in prison, but you might have very different prison terms.
Yeah. I also thought it was interesting, the differences in opinion on domestic violence charges should be felonies. That was interesting to me because of what domestic assault means in terms of fear and how they charge it out. There's different variances of it. And saying acting sooner may be more beneficial. I see that some people didn't agree with that, but it is an interesting conversation as we talk about domestic violence and where it falls on the crime of violence.
Any other feedback or commentary? Or what questions does this raise for you?
I mean, only that if you're on Century Avenue and you get pulled over on one side of the street, that's Washington County. You pull over the other side of the street, that's Ramsey County. And if I was gonna get pulled over, I'd turn to the Ramsey County right quick. But you can have different outcomes based on the side, I mean, literally based on the side of the street you get pulled over.
All right. Crime victims and advocates. Primary reviewers here are Commissioner Heath. Did I pronounce your name correctly? Heath. And then Commissioner Moore. What are the themes that stood out to you when going through this memo or snapshot?
Commissioner Moore, yeah.
Right next to you.
Go ahead, dive in.
Okay. So themes that I saw were interesting, some of the things that you noted. Victims feel like victim safety and accountability are really important and feel like that is not adequately addressed. The desire for sentencing options to include rehabilitation and mandatory treatment for both domestic violence and for substance use. I think another thing was being able to look at critical aspects of the offender's behavior. I think specifically with domestic violence, looking at risk assessment to make decisions around what departures might look like. Maybe that's more my personal opinion. Something else that seemed to jump out to me is that there was a little bit of a duality around wanting stricter or heavier consequences, but also wanting to balance that out with rehabilitation. But it really depended on what the crime was. And with domestics, it was really about needing accountability and depending on the level of crime or the history, that victim safety needed to really be looked at. But if there's possibility for rehabilitation and an ability to really secure victim safety, then really thinking about what that looked like is a complicated thing, I think, even for victims to figure out. But ultimately, I think what victims want is safety first, and I think openness to what that looks like, but ultimately safety and accountability. And then a lot about the imbalance in how we rank crimes and sentencing. And I hear this from victims a lot, especially on person crimes, that their person crime will not get charged or there won't be a conviction but then there'll be a conviction around something else, like a drug crime. And then folks will say, well, aren't you happy that they're in prison, at least for that? And it's very difficult for them to navigate because what they're actually hearing is that the drug crime is taken more seriously than the person crime that they experienced. And so really looking at how those things are weighed. And I hear that there is a different set of guidelines for drug crimes and for sex crimes. And it would be interesting on my second day to ask if we could look at something like that for domestics, so that we can really look at risk assessment.
On the comment that you made about the drug crime being taken more severe than person crime, there was actually a session that we had with the Native American public where a family came, and there were a family of a son who was a victim of dismemberment, and they mentioned how the specific statute they had an issue with. Throughout the sentence, the individual actually got sentenced severely because of some sort of drug-related thing instead of the actual dismemberment of the son's body.
Yes.
And that was a really painful thing. That was a really painful session, honestly. But yes, go ahead.
Yeah, I think it's really dehumanizing for victims when those things happen. Even though it seems like justice, it's not justice for victims. So I think it's a good thing for us taking that too. Yeah.
What I saw as themes here that recurred, there's frustration about the system kind of writ large. And the challenge with that is the system is not the Sentencing Guidelines Commission. The system is a multi-tiered criminal justice system that starts obviously with law enforcement, goes to the prosecution, goes to the court system, judge and jury involvement, and then obviously probation and sentencing, and concerns about the system not sufficiently prioritizing removing violent offenders from victims or society. That's a really complicated issue that goes well beyond, I think, what we're able to deal with as a Sentencing Guidelines Commission. But it does reflect, I think, public sentiment regarding the effect of violent and serious crime as opposed to the drug crimes, where the audience was much more focused on rehabilitative and less punitive responses as opposed to the domestics and the violent assaults. And the one theme around sentencing that recurs is the inadequacy of resources to encourage rehabilitation, ineffective or unavailable programming. We talked about the variations around the state in terms of the availability of treatment programs, both in chemical dependency and violence awareness. Concerns about the inconsistent use of judicial discretion on departures, particularly if you're in the seat of the victim looking at a downward departure on a serious personal crime case. You're going to view that maybe differently than you might on a drug case where there is a type of personal connection. And then I think there is an overall theme of general concern that sentences are more general and aren't narrowly tailored enough to individual circumstances. And this themes that we've talked about, the need for uniformity, but yet the ability to tailor sentences to holding people accountable, but hopefully encouraging them to do better and to not offend again. And do, sentences really, are they narrowly tailored, focused on offender behavior? But some really interesting comments, and obviously there was case examples that prompted some of these.
Yeah, and I think with person crimes, part of what's hard about the uniformity is that there's folks that very much, like thinking about the research data and the potential with having access to all of that, is that there's folks that very much grow up in situations where there's learned behavior and lack of resource, and being able to see that trajectory and put together like a different type of outcome where it's rehabilitation and there's possibility for transformation and what's the word? It's like restoration with that victim. I feel like that is a different type of outcome and offender compared to somebody who needs like a classical batterer perspective and has like a patterned behavior of violence. Criminal history looks really different. And like the outcome for that person should absolutely be different and like the sentencing guidelines for that person should be really different from this other person. So, yeah.
I thought was interesting on here is probation is overused in Minnesota, was a comment that was made, but then more desire for programming and what that would look like. There's a comment on here about mandatory domestic programming, that it should be a condition of probation. To my knowledge, it is. We don't discharge people in Hennepin County if they haven't completed domestic programming. They go back to court and get probation extension. It's required that you have to complete it. So this comment, I was wondering, do people assume that that's not happening? And I can't speak for every county. I just know in Hennepin, we don't discharge. It's one of the only cases that we don't. If you don't do it, you're gonna have to keep getting on probation until you finish it. So that was an interesting comment too on what the community may think or know about what we're doing with domestic cases.
For time purposes, I'll just go to the next session or the next audience. Treatment and rehabilitation service providers. So the primary viewer for here is Commissioner Crutchfield and Commissioner Sassina.
Sure. And we are joined by community member Dr. Raj Saringer, who always keeps me honest back there. And I think that one of the themes that came through was the feeling by a lot of the people that prison was damaging to the defendants, and that not only was prison damaging, but that it had terrible collateral consequences, and that it should be the nuclear option, and that we should look for other alternatives instead of prison as much as possible.
Yeah, I'll note a few themes that I pulled from this. I mean, one was, I think this is consistent with the formerly incarcerated people as well as restorative justice, which is interesting because, you know, restorative justice or a lot of these other alternatives are not specifically mentioned in the guidelines. I actually went and looked at the federal guidelines, and the federal guidelines do list some detention alternatives or sentencing options for judges to consider. Restorative justice is not one of them in the federal guidelines either, but things like electronic home monitoring, community supervision, and some other sort of non-custodial and non-probationary dispositions are mentioned specifically in the guidelines. So it made me think, you know, should we consider being more specific about sentencing alternatives in the guidelines so that particularly for new judges, new prosecutors who kind of look to the guidelines as an instruction manual for how to sentence, they at least start thinking about some of these alternatives. That also made me think about the pragmatic realities of how much time and energy and money has to go into restorative justice programs, and that there really aren't a lot of options to facilitate that kind of thing. A lot of commonalities with the drug case that I thought were interesting. I mean, so many different groups talked about how the sentencing in that case was excessive and treatment was necessary. That made me very curious as to what the facts of that scenario were. And then the other thing similarly, I guess, was surprising to me was the burglary case, because I heard this morning that the individual in that scenario had a prior felony conviction. And, you know, as a former prosecutor, I guess I was a little surprised that this group thought that that person didn't need a felony conviction. I think it's very standard in this state and state and federal court that if somebody had a prior felony and then committed burglary, that they'd get a felony conviction because of the risk of the public safety risk that's associated with burglaries. So that was an interesting one to me. I would be very curious what the facts behind that case were. I'll leave it there. Oh, and last thing, fines. I don't think anyone else talked about fines. And this group specifically mentioned or questioned the utility of fines for a drug case, which I thought was an interesting point.
first one, or do you want to?
To open it up to any other.
Any other questions?
Just make a comment to what you said about prison and
comments,
it being, detrimental. I think when we looked at that data set of the ACT score and all of that and how that plays into what we're doing, and then I'm like, well, there's a whole nother set of, in custody programming, the philosophies of different wardens, on and on how successful they are after their sentence. If we're trying to look at that data set on is a 5-year or 6-year sentence better or worse, there's so much, like everything leading up to that was identified, and then everything while they're in custody that affects that. So
That's a really interesting point. Thank you.
All right, law enforcement, we have Commissioner Brian Mueller, lone wolf. Should we take it on?
This is the classroom notes, this is the one where we didn't do sessions and we reached out to the associations that preferred the survey format. So that's why we have a little bit of a different type of data for this audience.
All right, so what themes stand out to you from this audience?
yeah, I just think first of all, it's important to talk about the lens that they're looking through. And so they don't deal on a day-to-day basis with the sentencing guidelines at all in any practical sense. And so they are dealing with victims and suspects at that frontline level. And so it's less practical, more emotional, I think. And so you're going to hear a lot of like victim-centered stuff. They want more victim input and focus because the law enforcement is dealing with them, throughout the entire process, and typically are the first ask, right before prosecution on why this sentence, why that sentence, why this departure. And so a focus on, what does prison look like in law enforcement? It's violent crimes, public safety, and repeat offenders. So the victim-centered repeat offenders, there's a huge view that there's these mitigated departures, and a huge shout out to the research staff for holding my hand through this. I was able to have a little one-on-one to kind of talk about this, so I can relay some of this information about what's really happening. But there's this view that the bench is departing a lot on a lot of these cases. They did identify that, and I think it's interesting, there's a view that repeat offenders, violent offenders should be in prison, but there's also an acknowledgement from the profession that, there is alternative sentencing solutions, but also saying probation is overworked. And so I think there's an acknowledgement from law enforcement that probation is, well, their caseloads are full already, and any alternative would just add to that. I think there's an acknowledgement from law enforcement that drugs like this real life scenario is like the case in point for drug courts of an individual that is dealing with addiction and committing low-level crimes specifically for the addiction. And there's an acknowledgement for, in law enforcement that we can deal with that differently than the actual, most drug courts will have the ability to work with law enforcement to say, no, this individual is selling drugs and causing lots of deaths by bringing, by selling this large amount of drugs. They don't typically have a drug problem. I think that's, another acknowledgement, persons, crimes, and identifying. There must have been an individual that works solely in, human trafficking or sex crimes, because there's a lot of conversation about that, but just an acknowledgement that there's, and kind of bore out today, at least with the registration, the mitigated sentencing for the registrations, that there's a need to focus on the sex crimes and the victims of those crimes.
Do you have any other themes that stood out to you all as you were reading the law enforcement section? And this is for the broader audience here.
I just want to say, I do like the comment that someone put the first-time offenders who demonstrate amenability to probation and treatment should be given their opportunity to make better choices. I can appreciate that law enforcement is saying that they recognize the importance of alternatives on that first offense and giving someone an opportunity, because that's not something we generally associate with law enforcement, just getting you in the door. And so I like the comment on that. Just want to put that out there.
I was going to say, I saw a little bit of attention because on the one hand, I felt like some of the comments were very nuanced and sort of said, hey, violent crimes should go to prison and treatment for some of the other things. Then there was a few comments that were like, if they commit a felony, just put them in prison. So I'm not willing, I don't think we should build that many new prisons. But I think that the theme about severity level and the right sentence, like that's really what I pulled from this the most, like that's really something that we should be thinking about. Which offenses, where should they be ranked? Which offenses really should be treated on the path to incarceration and which offenses should go a different path? And do we have that balance right, the way that the guidelines are set up?
I appreciate saying that, because coming from the position of not dealing with these, the actual sentencing guidelines, with the exception of being educated by prosecution, hearing all of these areas talk about confusion, like who would a victim or a suspect that, is in prison, or a victim who's been, victimized in this, who would they go to have all of this explained when you're talking about 87 different county attorneys and all the different judges and all the things that come into play? There's not one, it doesn't appear, at least from my view, that there's not one expert, I don't know, maybe we're supposed to be that, to be able to explain to someone how this is happening and how this is better for you or for the victim. So
Before you go ahead, to that point, a lot of the feedback we're hearing from the different audiences is that their go-to person was MSGC staff. And for them was like, we need to make sure that MSG staff has more staff and more resources so they can also help out the other system players. But go ahead.
I was just gonna react to I think in this one, and then also with prosecutors, there was a lot of discussion about victims and what victims want. And I was a prosecutor for a long time, and I think can be a little bit misleading to treat all victims the same, or to talk about them as though they are a monolithic group that all has the same views about crime. And just anecdotally, I know that in talking to individual victims, it's very difficult to predict what an individual victim, even in a similar type of case, thinks about a case. And I noticed that, I think victim advocates do a pretty good job of aggregating the information that they get from victims, but it never ceased to surprise me, like that certain victims would have experienced really serious results from a crime, but not want the person to go to prison for a very long time, or want something else from their involvement other than a long prison sentence. And then there were people that wanted really significant prison sentences, and I guess I came away from it feeling like a lot of it depended on the views that they had about the criminal justice system before they were victimized, and not so much what actually happened to them in this specific case. People just would come away wanting lots of different things. And so I think I will just speak as a former prosecutor, I think it's very easy for prosecutors to say victims all want X, Y, and Z, but until you go and talk to the specific victim, I think it's very difficult to predict what they want.
Go ahead.
So 2 comments. One about, just I'll follow up on the victim piece. So the prosecutors have a statutory mandate in our cases that we have to engage with victims and talk with them and listen to them and get their feedback and all of that. And I think it is true that the spectrum is wide. And we engage early because it kind of, they don't get to decide. We just take that as part of everything that we're trying to do and figuring out what does justice look like for them in this case, as the whole picture. And so, and it's hard because it is a wide spectrum. I think the other thing that I was thinking about, that I was hearing about this non-alternative forms of punishment, or I don't remember exactly how it was stated. I think one of the issues is that's a great idea, except that there needs to be also recognition that across the state of Minnesota, not every county has specialized courts that divert people from what I would say traditional courts. So like, let's say you're talking about lower level felony offenses for drugs, for example. If you don't have that model or that program or that availability for that resource in your county to do that, that's a population and a location in the state that now is not being able to participate maybe in sort of that option to, I won't say avoid, but to divert or to do something alternatively, that maybe it's happening in 40 other counties. And so I think, again, to Justice Moore's comment about some of this is way beyond the pale of the guidelines. I mean, there's a lot of resources that go into this whole big pot. And as we talk about alternative forms of doing something in the criminal justice system that may have implications if the guidelines are not, that's a resource issue that's way beyond what we do here, but recognizing that some counties don't even have those resources available to them in the first place.
Does anyone want to offer a follow-up to that comment? All right. We kind of went over time, but it's okay. So the question we want you all to think about and ponder about before we come back to you all after lunch is what patterns or themes stood out to you from all the presentations this morning, including Urbana University of Urbana Institute, and then I believe the judges will also have a presentation as well too.
Are we doing theirs now?
Can we do the judges?
Yeah, so after the judges' presentation, I want you all to think about, from all these presentations this morning, what are the patterns or themes standing out to you all?
So we're not answering this now, we're just previewing you the question that we'll be asking you after lunch. With that, I think we'll hand it back.
Are we doing the judicial input now?
Yes, ma'am.
Let's do the judicial input. So that was Judge Larkin and all the judges, actually.
All the judges. So we did our own survey through State Court Administration. And in addition to that survey, to which we had a pretty good response rate, we had a listening session that I was not able to attend due to illness, but Justice Moore and Judge Knudsen headed that up, and it's my understanding that was also well attended and a lot of good ideas shared. The snapshot that we bring to the commission is based primarily on procedural issues that were identified with the guidelines. And I think, Nate, you have there we go. So one thing we asked were, what are the aspects of the guidelines that are working well? And I think what's interesting about the 4 responses you see there are that, they focus on the ability to settle cases with negotiations. I mean, the judges like that everyone kind of knows what the outcome will be, that helps people assess their risks, make good decisions about how to handle their cases, and enabling plea bargaining. And like it or not, I don't know, the number is astronomically high. Majority of cases are handled with plea bargaining. So most people that engage in that want to know what the worst case scenario is, what the best case scenario is. Judges are not allowed to participate in plea bargaining, and sometimes pleas get tossed if they're viewed to have done so. So I think it's important that the guidelines serve that purpose. One suggestion that the judges had was that, having a significant range in some of the presumptive sentencing boxes allows for a little more discretion and allows for a little more negotiation between the parties, so they liked that. We also asked which aspects of the guidelines are not working well, consistent with what we've heard from everybody. No one likes having to deal with out-of-state convictions. For those of you who don't know, the problem with out-of-state convictions is you can only count an out-of-state conviction in a criminal history score if the offense itself is the equivalent of an offense that would be a felony offense in Minnesota, and if the person actually received what would be the equivalent of a felony sentence out of state. And the burden is on the prosecutor to prove those two things at sentencing. And what we're seeing happening a lot is that, the PSI will say, these are the out-of-state convictions. The defense doesn't challenge whether those are accurately stated in the PSI, so everyone relies on them. And then on appeal, the defense says, well, the state didn't prove those 2 factors, this shouldn't be included. And what the case law says now is because a criminal history score that's incorrect is illegal and can be challenged anytime. When that happens, the case gets kicked back to the district court, where the prosecutor then has the burden to prove that it was in fact a felony in the other state and a felony sentence was imposed. And what we heard from our colleagues was a concern that sometimes the prosecutors, they can't do that because other states, and Illinois is notorious, I remember this as a public defender, don't have good records. So there's really no way to prove what was the offense, and to even know the sentence. The harder part is you do have differences between statutes. I mean, you can have a crime here where this is a felony. Well, in another state, well, it might be a gross misdemeanor, it might be a felony. It depends on exactly what the person did. And you might have a trial, you might have a plea, you might not have a great factual basis, you don't have a transcript. Sometimes there's just no way to prove this up. And so the concern was that prosecutors may just not even ask for inclusion of the out-of-state conviction because it's either impossible or too difficult to prove it up. Well, then you're left with a situation where people aren't being treated the same, because if you had these convictions in Minnesota, it's automatic. But if you have a lengthy criminal history in another state that doesn't keep good records, we're not going to count that in your score. So we're really not treating people the same. So lots of concerns about the use of out-of-state convictions, but as I hope I've just explained, you can't just say don't consider them, because that seems inconsistent with the purpose of the guidelines, to have consistency among offenders. They don't like unranked felonies. They mainly don't like it because, you know, they give one ranking, then it goes up on appeal and they get reversed. And they're like, could you just rank all of these things? Because it also does give another opportunity for inconsistency, because from one judge to the next, and whether there's an appeal, it seems like it would just be better if these things were ranked. Complaints about 1/2 points and custody status points. I know there is guidance out there and there's case law. I think everybody once and for all would just like the guidelines to make a decision on how to deal with those things. Concerns that mandatory minimum sentences aren't cross-referenced in the grids. That's a pretty technical and easy thing to fix. All that changes year to year, but there was concern expressed that people don't realize that there's a mandatory minimum, and everyone kind of goes along based on a PSI with a sentence and then learn that there was actually a mandatory minimum that wasn't imposed. Few people raised concerns about Hernandizing in sentences, and the concern is one that we've talked about as a group, which is, you know, there are certain areas, and child porn is the biggest one, where depending on how a prosecutor charges something, you could have somebody who's getting probation or someone who's going to prison for a very long time, because under the case law, every image, I believe, is an offense. So a prosecutor, you know, you find 1,000 pictures, could charge 200 counts, and then Hernandizing means you stack the sentences. So that person's going to prison. In another district, it might just be charged as 1 count and that person's getting probation. But again, that's another example of a system and something judges can't necessarily control, but it's something they're seeing and raised as a concern. Then finally, the layout of the sentencing guidelines. I think one person said, you know, everything you need is in there. It just takes forever to find it. Why can't it just be organized in a way more like the rules, more like statutes, where it's just sort of easier to find what you're looking for? Then the final question were suggestions to improve the current guidelines, and they're consistent with these themes, which is to rewrite them and reformat them, to simplify them so they're easier to use, to rank all offenses, simplify custody status, have the presumptive sentence cover a wider numerical range to allow for more differentiation based on the particular fact of a case without having to go the departure route. Include the reference to mandatory minimum sentences in the grids themselves. I mean, the grids do say, well, this doesn't apply if there's a mandatory minimum. I think they'd like the grid to actually tell you what the mandatory minimum is. And also suggesting that it would be easy if we had a grid or chart indicating when to sentence concurrently or consecutively. Those were sort of the procedural concerns and suggestions from our colleagues. Anything to add based on those who had the
Well, the listening,
luxury? Yeah.
the listening session was well attended. We were actually pleasantly surprised by that.
Shocked. Shocked.
They gave us the 7:30 a.m. slot. But they fortunately moved breakfast to the area we were,
So they had to attend?
It almost turned out to be that way. We were very concerned about that. And 300 some people say, what's this? I thought I was just gonna have a cup of coffee, and you're going to lecture me about the guidelines.
I was recovering from surgery and I got an emergency text from Jeff. Did you agree to this? I said, no, get to another room.
one of the largest frustrations for district court judges is getting that departure report back from the guidelines claiming that you departed in a case where you never intended to depart. In fact, there was never a discussion of departures. Usually it was to the contrary, where everybody agreed the departure wasn't appropriate, but because of a mistake in criminal history computation or application of the guidelines, suddenly you get told that you departed. And that's a recurring frustration. And so there is some desire for the commission to implement something similar to like an online child support guidelines, where you could have like real-time information in an effort to provide more information to avoid unwanted departures. That was something that was talked about. There was a kind of a robust debate as to whether or not misdemeanors should even be factored into the sentencing guidelines on the grounds of some concern about disparities of coming from that disproportionate responses. There was actually some give and take on that. There was not consensus on that issue. So I think there was a sense that we could have more technology-based information. And then there was one comment I thought was, you know, the federal guidelines factor in some things that the state guidelines don't. And so some of our judges who are former federal prosecutors noted was the acceptance of responsibility, you know, element that might be factored in more directly into the guidelines. You know, how much of a part that plays in you know, judicial discretion on sentencing. Judge Knudsen.
Well, like, we kind of started off and joked about it, but we were, you know, we got on the agenda, thankfully, to Judge Effers and Judge Larkin. And because that's planned a year in advance, but so they throw us on at 7:30 in the morning. And so Justice Moore and I were figuring, well, maybe 4, 5, 6 people might show up. Over 60 people showed up. Oh, wow. And so our report, our summary is based on a survey of 8 questions or so that went out. Right. And I think we had how many responses? 50 some responses prior to our listening session. So we were really amazed at the interest and the feedback. And the comments then that we got at the listening session of the appreciation for the work of the Sentencing Guidelines Commission. Several judges mentioned, and people weren't always aware of it, but the annual report, the statistics, the data, it's all provided on our website, and the work that the commission does. And then, of course, the opportunity to provide this feedback. So much appreciation from the judges about that. The criminal history score, I think this is a procedural issue within our, as Commissioner Reeves was saying, you know, how do we process it? When do we get it? When do we request it? But that really is a problem. Can we fix that? Can we do something on the sentencing order that says, as Justice Moore mentioned, this is not a departure. I did not intend to depart. When it comes in and say, oh, you departed. Well, I didn't mean to. No, but it's clear to everybody. Everybody remembers. Everybody understands what that sentence was intended to be. The other thing on the departure form is the judges, you know, not always going to take responsibility for their own decisions. Well, so the question is, did the prosecutor agree? Did the prosecutor object? Or the prosecutor takes no position? Get rid of takes no position. What do you think?
I'm not saying nothing.
Taking no position.
No, big X on that.
A lot of interesting suggestions. A lot of commonality, as I guess we can get into after lunch. Unranked offenses, why we struggle with them, just rank them. You know,
Right, make everybody's life easier.
And yeah, that's it. Otherwise, a lot of commonality with teams.
Commissioner Mitchell.
I have a question for you. On the unranked offenses, there's not that many of them, but I have to say some of those I've actually appealed. So in there they seem to be ones where the facts can be so different depending on what it is. Like, for instance, aiding an offender after the fact. The facts can be so different that it seems like it is a hard one to actually, for us to rank, given we don't know what the facts are gonna be. And so I guess I'm kind of curious if, from the judge's perspective, I mean, everybody, nobody likes them. And there seem to always be an issue. Sometimes I've seen where the plea negotiations will decide that, or they will have two possibilities, and then the judge decides. But some of them I think, yeah, we should probably rank them, but there's some where the facts can vary so much.
There was a discussion about that. So, okay, if you're not gonna rank them, give us, how are we supposed to make a decision on it? Can you give us some concepts or elements to consider as we go through this, so that the defense attorney and the prosecutor and the judge are all kind of on the same page, examining and analyzing what it should be?
So I actually had 3 different ones over a period of time. They were all counterfeiting currency. And you'd think that would be an easy one to rank. And to Commissioner Saxena's point, I think, like for our theft crimes, we have, depending on the thresholds for the theft or the damage, that changes the penalty provision, so that could affect ranking. But I never understood why that particular crime couldn't have been ranked. And so fortunately, I had different defendants, but the same judge. And so whenever we got the first one ranked, whether I liked it or not, now I had that to sort of contend with in the cases that came after that. But I do agree that there are enough of them, and I think that we could probably put some framework around it that would help everybody in the system with more sort of guardrails on it. That we really should put that on our list to do and to tackle, because I don't think it's that hard.
Sorry, I don't want to belabor this unranked offenses thing if we're trying to get orange, but another one is racketeering. Okay, well, racketeering can be violent crime related racketeering. It can also be like I have a lot of Medicaid fraud related racketeering. And I think what the federal guidelines would do is give a cross-reference to the underlying offense, or to whatever offense is most similar to the underlying substantive offense. Whereas I think in state court, what I've observed anyway is that prosecutors just pick what they want the severity level to be, because like the AG's office wants Medicaid fraud to be very serious, so they pick a 9. But when you compare it to the other things that are a 9, like I think murder and manslaughter, it's really difficult, I think, for a lot of judges and defense lawyers to wrap their head around where we're coming up with some of the severity. So I would like to consider, if it's racketeering based on a violent crime, okay, well, let's look at the severity level for the violent crime.
All right. This is all great, but we do have to keep moving. So thank you to Matt, and thank you to the judges for getting all of the feedback. This has been really, really interesting this morning, and I also really appreciate all of the engagement by commission members. Exactly what I was hoping that we would do today. I'm going to split the difference here. We had planned to have lunch go till 1. I'm going to give you till 1:05. And then we will come back.
A little better.